By Senator Orrock of the 36th, the resolution honoring the life of memory of Robert V. Irvine and for other purposes. Senate Resolution 1272 by Senator Jones of the 10th, a resolution honoring the 90th anniversary of Goodwill of North Georgia and for other purposes. Senate Resolution 1274 by Senator James of the 35th and Wright of the 33rd, a resolution recognizing and commending Dr. Ramona Jackson Jones on the occasion of her retirement and for other purposes. Senate Resolution 1275 by Senator Davenport of the 44th and others, a resolution recognizing and commending Dr. Mary Schmidt Campbell and for other purposes. Senate Resolution 1258 by Senator Tate of the 38th and others, a resolution honoring life and memory of Ralph David Abernathy III and for other purposes. Senate Resolution 1273 by Senator Henson of the 41st and others, a resolution recognizing Liz Flowers and thanking her for her service as Executive Director of the Georgia Senate Democratic Caucus and for other purposes. Mr. President, that completes the order.
Is there objection to adoption of the resolutions? The chair is none. The resolutions are adopted. We're ready to take up the next bill. Senator from the 6th is up next. Senator from the 6th. Well, we'd like to welcome our former Majority Leader in the House and now Board of Regents member, Larry Walker, here with us today. I tell you, very good. Good to see you. Chair recognizes Senator from the 6th.
Mr. President, I ask for unanimous consent to remove House Bill 937 from the table.
937, is there objection? Without objection, the Secretary will read House Bill 937.
And you can begin just regular.
House Bill 937 by Representative Harold, the 106th and others, a bill to be entitled an act to amend Code Section 48-8-3 of the OCGA relating to exemptions from state sales and use tax so as to change the sunset provision for the exemption for projects of regional significance, to provide for related matters, repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill do pass by substitute, respectfully submitted by Senator Hill, the 32nd. Mr. President, the Senate Committee on Finance offers the following substitute to House Bill 937, a bill to be entitled an act to amend Code Section 48-8-3 of the OCGA relating to exemptions from state sales and use tax so as to change the sunset provision for the exemption for projects of regional significance, to amend Article 8 of Chapter 8 of Title 50 of the OCGA relating to regional economic assistance projects so as to provide for the qualification of certain projects as regional economic assistance projects, to provide for criteria for such qualification, to provide for refunds of sales and use taxes for such projects, to provide for the continuance of certain levies for financing, construction, or improvement of facilities adjacent to such products, to provide for related matters, repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator from the 6th. Present the bill. Ask the Senate to come back to order. We've got bills we're taking up.
Good afternoon, friends. Today I bring to you House Bill 937. The Georgia Department of Economic Development is seeking to renew the sales tax exemption for projects of regional significance. The exemption was originally created in 2012 with a 2-year sunset. The sunset extended by the General Assembly in 2014. The bill seeks a 3-year extension, which coincides with the end of Governor Deal's term. And this incentive is used only for large projects that have regional economic impact. Only a limited number of the projects have received this designation and incentive. Each project receiving this incentive, on average, has created over 1,800 jobs and more than $650 million in investment. This exempts the sales and use tax on construction materials used in a specific project. This tax exemption does not include labor costs associated with the construction of an eligible facility. The projects must be competitive, meaning there is an incentive offer from another state or country. Once competitiveness is determined, projects are evaluated based on 4 criteria. Number 1, the amount of jobs created by the project. Number 2, the amount of investment created by the project. Number 3, the per capita wages paid to jobs created by the project. And number 4, the geographic location within the state of Georgia. So that's the first aspect of the bill. We're simply extending this impactful program for another 3 years to coincide with the governor's term. As we all know, our governor and the members of the General Assembly have done great work to make Georgia the most economically competitive state in the nation, and our Department of Economic Development has been very instrumental in making the necessary deals to expand our economy and create jobs. The second part of the bill, Section 2, is it's going to create criteria that allows for projects that meet the criteria listed in the bill to be considered to be a project of regional significance. For example, or for a specific example, if you have an investment project of over $400 million and the area has been designated for the last 20 years as an underdeveloped area, then it can qualify for one of these projects. And secondly, it also allows for the authorization of the local jurisdiction to extend a rental car tax for the purpose of issuing bonds. If there are no questions, I will yield the well, and I do ask for your favorable consideration.
Chair recognizes Senator from the 39th for a question.
Will Senator yield?
I will.
Can you give us a few examples of these projects of regional significance that have been put together under this program?
I believe Baxter was one of them, and like I said, there hasn't been this prospect has not been used a lot, but Baxter's one of them, and that's all I have offhand. The Department of Economic Development would have more, and I may have left them on my desk, but it has not been a project, an apparatus by the Economic Development Department that's been used a ton.
Thank you.
Any other questions, Mr. President?
Yes. Chair recognizes Senator from the 45th.
With the Senator Gill.
I will, thank you.
Senator, is it not true that this potential for redevelopment, that areas have been in blight for potentially over 50 years? Is that not true?
It is true.
And is it also not true that that is what presents the language in the bill that says significant regional redevelopment?
That's true.
Senator, is it not true that $400 million is really the basement level, that potentially the level could be double that amount? And that's why regional significance is so important and so imperative for economic development, especially in a region that has poorly performed for decades. Is that not true?
Absolutely true. Thank you. And I will say as well, not all tax credits are created equal. And we pass a lot. Sometimes I disagree with them. But the reason I think this is a viable one is it sort of meets my criteria, which is 5 things. Number 1, it creates jobs. Number 2, it creates economic activity that otherwise would not ensue. And that's what you're pointing out, Senator, about the fact that these areas have been underdeveloped for 20, at least 20 years. The 20 years is the minimum. And so projects won't ensue without an economic incentive, and so that's why it's important. Number 3, it expands competition. Number 4, payment from government is on the back end. There's no front end investment with this credit, and so I think it's very viable. And then number 5, multiple governments are participating. It's not just the state government, the locals are participating as well.
Would you further yield for one last question?
I will, thank you.
Would you not say the difference in this particular bill and this particular redevelopment, unlike Baxter, unlike Caterpillar, unlike the plant down at Columbus, those were just plain old pieces of land. This is areas of high crime, high taxpayers' usage of dollars because we're fighting crime. We're having to take care of people that are living in these underdeveloped areas. That, to me, would you not elaborate on that? The criminal element and that undeveloped area, that is much more significant than a raw piece of land that you're developing. This is land that is using money, using taxpayer money.
Senator, it's an additionally a great point. It's specifically if you're speaking of downtown Atlanta in this case, there's no economic activity currently going on here. There hasn't been for 20 years. There have been repeated efforts to create economic incentives and activity, and all have failed. So I appreciate your point. It's a very valid one.
Chair recognizes item 26 for a question. 26.
Gentleman Yale,
Yes, sir.
what kind of response have you gotten from the rental car folks by adding this tax, by making it available to use rental cars with a certain tax for this?
It's a great question, Senator, and the answer is this does not add a tax on them. What this provision is going to allow is for the tax, which currently sunsets in the year 2038, to be extended to 2047 if a project is awarded, so that you could put 30-year bonds on them. So it's not a new tax, it's an extension on a current tax.
Chair recognizes Senator from the 36th.
Thank you, Mr. President. Does the Senator Yield?
I do.
And apologies if you've already made this point, but it's important to lift up the fact that your language specifically excludes projects involving casino gambling, because as the legislature, we've not yet had a will of the bodies to go down that road. So that's language on line 48 clarifies the fact that it could not be used in that instance.
I appreciate that, Senator, and that is absolutely true.
Thank you.
No further questions, Senator. Chair
you, Mr.
recognizes Senator from the 31st to speak to the bill.
Ladies and gentlemen, there's probably a lot of things that you need to be very cautious about today, and I don't know, I feel like I spend a lot of time down here talking to you about the Constitution. I think we all had a copy of that on our desk on the first day. Some of you may have misplaced it. This is a bad bill. Not only is it bad, it is blatantly unconstitutional. Now, I had a copy of a letter from Legislative Council dated March 21st copied and placed on your desk. A number of you have come to me because you saw the letter and you didn't have one on your own desk, so I've asked that they be redistributed because you need this. What this bill does is it writes a check to the developer of a piece of property for the amount of sales taxes that he collects from his people that do business there. Now, he collects those sales taxes, remits them to the state, and then we write him a check for the full amount of the taxes. So we're paying a developer for taxes. This is not a refund. We are outright writing a check to a developer for taxes that he did not pay. I was down here a few minutes ago talking to you about sales tax on manufactured homes. This is much more egregious than that measure. The Constitution clearly states that we cannot do this. There's a letter on your desk. I've underlined a few of the important parts for those of you who don't care to read a whole lot. This is a gift to a developer. We pay the developer for taxes that were remitted on purchases on that property, and it's even greater than the amount of taxes that he collected for the state. We are paying to the developer the taxes that the purchasers paid for local issues, such as education, ELOST, and MARTA tax, and their local sales taxes. So I would urge you to be very cautious about this. I want to point out a couple of things in this bill. Line 38 talks about chronically undeveloped. Underdeveloped is the word. Those of you who are very interested in the environment seem to talk to me a lot of days about underdevelopment. Not everybody likes development. There's some parts of the earth that are not worth developing. So that's irrelevant. On line 39, there's a word over there about 2/3 of the way across that if you ever see in a bill, you need to study. When you see deemed in the code or in the bill, that should raise a red flag. That means it ain't what it looks like it is, but we're going to call it that. So I urge you to oppose this because of its unconstitutional nature and because you owe to the people of Georgia to spend the money that they pay in taxes, those hard-earned dollars, to spend them wisely. Mr. President, I'll yield the well, or I'll take questions if somebody wants to do that. Thank you.
Chair recognizes Senator from the 49th. Speak to the bill.
Thank you, Mr. President. I appreciate the opportunity to speak to the bill 937. And I appreciate the Senator from the 31st's caution, and I appreciate his viewpoint. I happen to disagree in a number of areas. I don't think there's any part of this state that is not worth developing. And developing doesn't mean you build a building on it. Developing doesn't mean you build a football stadium. Developing doesn't mean that you have a housing development. Developing might mean that you grow cotton on it, that you grow corn on it. The word development does not mean necessarily building buildings. The question earlier was regarding, so every part of this state and this country is worth attention. Every part has value, just as every individual has value. The question earlier was how many of these projects have gone on and so forth, and what are some of the other ones. Caterpillar was one. Engineered Flooring up in Northwest Georgia was one. Baxter Pharmaceutical was one. There have been a couple of others. I don't recall the others offhand. This is a competitive initiative. This property we're talking about getting the rebate on the taxes, the developer getting a rebate on the taxes. Well, what would we rather have, a part of something or all of nothing? Right now, we're getting all of nothing. We will never get anything out of this property if we don't invest in it. And it's right here in the heart of the city. Right in the heart of the city. How could we say no? How can we turn a blind eye? How can we say no, it's not worth developing? We can't. This is an important piece of property. This is an important initiative. This is an important opportunity for the state of Georgia and the city of Atlanta to move forward. DCA has to be on board. Economic Development has to be on board. Department of Revenue has to be on board. This is not a quick fix. This has only been done less than a half a dozen times in the history of this state. And this is a meaningful and valuable piece of property, a meaningful and valuable initiative and bill. And Mr. President, if there are no questions, I'd yield the well.
There are a couple of questions.
Thank you.
Chair recognizes Senator from the 45th for a question.
Senator Yield.
Certainly.
Senator, would you not say regional significance would encompass the Georgia Dome, the World Congress Center, Centennial Olympic Park, Phillips Arena, that is truly the golden triangle in the heart of the capital of the state of Georgia? Would you not say that is worthy of investment?
The heart of Atlanta, the Empire City of the South, the Empire State of the South, this is right in the heart of it. You're absolutely right, Senator. I would agree with you 100%. This is dead center. This is the target. This is ground zero. We are getting nothing out of this property, and we never will get anything out of this property the way it exists today. Yes, ma'am.
Senator, is it not true that this area, and one of the main reasons it hasn't been redeveloped, is because this is where the railroad, CSX, the main terminus for Atlanta, is located in that area? And part of the problems over the years has been the fact that they're very difficult to work with. And it takes the state's imposition into the project to be able to do this redevelopment. Is that not true?
That's true.
Chair recognizes Senator from the 31st for a question.
Thank you, Mr. President. Does the senator yield?
Certainly.
You mentioned a couple of things there that kind of caught my attention. You were first talking about development might be developing a cotton field. Are you aware of anyone with a cotton field that sells that cotton and collects sales tax for the state?
No, sir, I'm not. I was using that as a figure of speech, but thank you very much for bringing it to my attention.
Are you further yield?
Certainly.
You understand that what this bill does is pays a developer for taxes that they did not pay. And while that would be like paying a row cropper who produces this cotton for the sales tax that was paid on the blue jeans that was bought because it was made with the cotton that grew in his field.
I'm sure the senator knows of what he speaks.
You further yield?
Certainly.
You mentioned Baxter. I think you were talking about the other part of the bill that the sponsor.
Yes.
Right. The other part of the bill was actually has been used for a very useful purpose, but the sponsor of the bill sought to have an amendment placed on it in the Finance Committee that expanded it into an area that is clearly unconstitutional, and it is that part that I spoke about.
That is
not
true,
not the underlying bill.
That is true, Senator.
Thank you.
Thank you.
No further questions.
Thank you, Mr. Senator. Thank you, Mr.
Chair recognizes Senator from the 6th. Close the debate. Hold on, Senator. Well, we have a late arriving amendment. by the Senator from 28. Let me have. The bill is, this is an engrossed bill. This is an engrossed bill, Senator. Chair recognizes Senator from 6.
So, thank you, Mr. President. I'm going to be brief. A couple things were said, and we just need to clear the record. The senator from the 31st said that a developer is going to get money that they didn't pay. The way this process works is if you qualify, and by the way, our governor's Office of Economic Development has been highly judicious in awarding these projects and very successful in implementing them. But the way that it works is there's not one dime of investment from this state into a project of regional significance until economic activity ensues. In this case, after the development is done, tax dollars will then come into the state. And the senator from the 31st mentioned that they're going to get a 100% rebate. It's not true. The Department of Economic Development is going to be able to determine how much it is, but it's not going to exceed 25% because that's the historical amount, you know, but they'll get the opportunity to make that deal. So let me explain. If you're making $100, currently we're making $0. If we're bringing in $100 of tax revenue, then we're going to give the developer back $25 because they created economic activity and jobs that otherwise would not be there. And then one other thing is we kept talking about a specific property. This may be used for a specific property, but this is not just for a specific property. I'll take you to the language. The owner of a project having a minimum of $400 million in projected capital investment for the redevelopment of an area certified by the commissioner to have been chronically underdeveloped for a period of 20 years or more. This could occur in any one of our districts across the state, that criteria. So I just wanted everyone to be armed with the facts here, and the facts are there's no state investment until economic activity ensues, jobs are created, and people are making money, and then the state begins making money as well. And then finally, this could occur in any of our districts if the Department of Economic Development has deemed it appropriate. Thank you very much for listening to me, and I really appreciate your favorable consideration. Mr. President, are there any questions?
Chair recognizes Senator from the 31st for a question.
Does Senator yield?
I do.
You mentioned this, I believe you referred to it as historically didn't pay more than 25%. I think you were talking about a different part of the bill, but let me direct you to lines 41 and 42 where it says, shall not be limited by paragraphs 8 and 11 of Code Section 48-8-271 or by subsection C and F of Code Section 48-8-273. Are you confident that you understand how this actually works?
I'm confident I understand what the language says, which is that it's not going to be constrained by the tight limitations drawn out in that code. And the reason for that is in the code, and I can't remember the specific number, but it highlights exactly how much the governor or the Department of Economic Development can enter into an agreement on how much they pay back. And it's like 2.5%. It's very low, and I don't remember the number. But what this is going to allow the Department of Economic Development to do is to raise that above the constraints that are currently in the code, because this project, you know, is so economically unviable currently that a deal has to be made for it to ensue, and so that gives the Department of Economic Development the ability to make a deal.
And what a deal it would be. Thank you.
Chair recognizes him 39th for a question.
Will Senator yield?
I will.
Let me ask you a question regarding the viability of these projects. Is it true that many of the projects that you're discussing would not otherwise be developed if not for this action we're taking today? Is that true?
It's true, Senator. There's no local tax revenue coming in from this property. There's no state tax coming in from this property. There's no jobs created as a result of this property, which I mentioned has not been developed on at least 12 tries. There's a number 20 that's in my head too. The business community won't go down there unless there's some help, in this case, from the state and the local government. We win. The local government wins, the state government wins, and the citizens win because they have economic viability in an area that's otherwise blighted and undevelopable. I think
Chair recognizes Senator from the 28th for a question.
my good friend.
Thank you, Mr. President. Will my good friend yield?
I will.
The concern, this is the reason why I voted against engrossment on this one. The concern on line 36 is the word projected. So what happens when they show that this project is projected to cost $400 million, but it doesn't in the end, and they only spend X amount of dollars on the project? It could be as low as $5 million, but as long as they get the upfront, there's nothing there that requires that we back off of what we extend to them. All they have to show is a projected cost, and I could do that all day long. Is that not true?
You know, the way you're reading that, I can't argue with it, but the bottom line is you know, we can't sit in this room and act like this department has been making all these deals. They just haven't. There's been a very few that have qualified under this. And, you know, I wouldn't be for this, Senator, if this didn't have a sunset. But we're giving a guy, in this case, the governor, the opportunity to continue to use this apparatus that we've created in law to create economic activity. He's done a good job with it. I believe he will continue to. And so that's why this thing sunsets in 3 years.
Would the senator further yield?
I will.
Can you, based on a $400 million project, let's just assume since that's the threshold, that's the cost, if we
Minimum.
may.
Minimum.
What are the dollar amounts of these rebates per year for the next 30 years?
That's what the Department of Economic Development negotiates, and as I've said, it's sometimes 10% and sometimes 25%. I don't know. I'm not in there.
Of what number, Senator?
So of the sales tax revenue that's coming in from the economic activity that's been created, you know, we get 4% sales tax on goods and goods sold in this state. And so if it's $100, that's $100 that wasn't going to be created prior to us doing this. We give them back 20% of that. That's, for example, I can't tell you what the deal is because I don't know, but 20% of that would be given back to the entity.
I understand. One further question, if I may, good friend.
Yes.
Okay. Is it possible that that's 100% rebate?
No.
How is it not possible?
Because that's silliness. That would be silliness.
To my point. Thank you, Senator.
We need that. Chair recognizes Senator 45th.
The senator yield for two last questions. Is it not true when you're looking at $400 million in projected capital that big corporations, when they come in, they have plans, they have conceptual drawings, they have engineering plans, that you're pretty much guaranteed you know the nature of the project, you know what the anticipated revenue is, and you know that we're on the upswing of coming out of a recession, you know that it's very practical. Is that not true?
It's very true, and having been in the development business myself, the number usually doesn't go down, it goes up.
Exactly. Would you further yield? I know that we have been talking specifically about the city of Atlanta, but this is true. A regional significant project could be in Savannah, Georgia, because Savannah has some blighted areas also, and it's a major tourist destination. Savannah would be a great example of where another project could be located. Is that not true?
Absolutely. Columbus, Macon, any of our great cities. Thank you, Senator.
Chair recognizes Senator 31st.
Thank you, Mr. President. Senator yield, maybe for only two.
I will.
So thought I heard you say that there was no property tax on that property today. Did you mean to say that?
I didn't. What I meant to say is it's not going to be as high. Obviously, there's property tax on every property, but it's property tax is based on the value of the property, so it will certainly go up, thereby yielding more revenues to the city of Atlanta after this project is done.
Senator, further you.
I will.
You keep talking about a sunset. Could you show me where the sunset is on Section 2?
I cannot. And the reason that I said that there was one is because it goes. I made a mistake, Senator. I thought that it was in the code section that we were amending on Section 1, but it's not. It's a different code section.
Would you agree that this creates a grossly unconstitutional provision in perpetuity in the code without that sunset?
Absolutely not, and I reject your claim that it's unconstitutional. We're engaging, we're currently engaging in this activity whereby we incentivize economic development and we do rebates of the sales tax, which was prior agreed to. If it's unconstitutional, then somebody will need to go through that process and tell us so. But it's currently being used, and it's not unconstitutional in the way that it's being operated.
So you believe that Rick Ruskell and Wayne Allen do not understand the Constitution of the state of Georgia?
No, we had this conversation in the Finance Committee meeting, as you recall, and just like the issue the other day on the boat and the ad valorem, it's unclear.
This one was not unclear. This one was very clear. There is no ambiguity in the letter that
Senator,
comes from
he was suggesting that these are gratuities. I reject that claim. These are not gratuities. This is a rebate of a sales tax, not unlike we do with our citizens and businesses all the time from the Department of Revenue.
Would you yield for another question?
Yeah.
So in the letter that came from Legislative Council, it says this is the Supreme Court held in the Atlanta Chamber of Commerce versus McRae, 174 Georgia 590, 1932, that the government could not constitutionally appropriate funds for grants to the Atlanta Chamber of Commerce and similar entities. So you are arguing that not only is our council wrong, the courts are wrong, and the Constitution is unclear.
It's a misapplied case, in my opinion, that this is not a grant. You talk about a grant to the Chamber of Commerce. This is not a grant. They paid in taxes. We gave them a portion back. I don't consider that a grant. Mr. President, I'm going to yield the well, but I do ask for your favorable consideration.
Senator has yielded. The senator has yielded. Question is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection agreed to report of committee which fail to pass the bill? Chairs none, report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none, main question ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes Senator from the 45th. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that House Bill 937 passed almost unanimously through the Finance Committee because those members understood the economic development of the state of Georgia as imperative?
Senator has great passion for this, and I know she is well aware of which she speaks. And it appears that many members in this body agree with her. On the passage of the bill, the yeas are 42 and the nays are 8. And this bill, having received the requisite constitutional majority, is therefore adopted. Chair recognizes Senator from the 49th. Hold on, Senator from the 6th, your light came on by accident. Chair recognizes Senator from the 49th.
I'm not.
49th. No. Well, you need to move, so you'll want to move it off the table.
I ask unanimous.
No, I'd pick up the microphone. I tell you what, let me give you the instructions and
unanimous
see if you
consent.
can follow.
To remove House Bill 364 from the table.
Is there objection? Oh, there's objection all over the House. Now, without objection, the bill will be removed from the table. Secretary will read House Bill 364.
House Bill 364 by Representative Knight of the 130th and others, a bill to be entitled an act to amend Chapter 6 of Title 48 of the OCGA related to taxation of intangibles so as to change certain provisions regarding the real estate transfer tax, provide for an effective date to repeal conflicting laws and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill do pass by substitute. Respectfully submitted by Senator Hill, the 32nd. Mr. President, Senate Committee on Finance offers the following substitute to House Bill 364. A bill to be entitled an act to amend Chapter 5 of Title 48 of the OCGA relating to ad valorem taxation of property so as to revise and change certain provisions regarding the approval of tax digest by the Commissioner to impose sanctions for including non-taxable properties on the tax digest, to provide for procedures, conditions, and limitations, and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator from the 49th to present the bill.
Thank you, Mr. President, for your patience. This is a real simple bill. House Bill 364 does two things. Provides a tool for the Department of Revenue to address illegal taxation, and it permits taxpayer access to the Georgia Tax Tribunal. If there are no questions, Mr. President, I'll yield the will.
There are no questions, Senator. Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Granted, report of committee in favor pass the bill. All those in favor of the bill? Vote aye. Those opposed, no. Secretary, unlock the machine. Senator from the 7th will stand by. 7th will stand by. You'll be up next. On the passage of the bill, the yeas are 48, the nays are 0. This bill, MC Rex Constitution majority, is therefore adopted. Chair recognizes Senator from the 7th.
Mr. President, I ask unanimous consent to remove House Bill 806 from the table.
806, is there objection? Without objection, 806 is removed from the table. Secretary will read House Bill 806.
House Bill 806 by Representative Tanner of the 9th and others, a bill to be entitled an act to amend Chapter 5 of Title 40 of the OCGA relating to driver's licenses so as to provide for the expiration of certain licenses and identification cards issued by the Department of Driver Services, to provide for the suspension of a driver's license upon receipt of convicted reports from a court, to provide for related matters to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Public Safety recommends that this bill do pass. Respectfully submitted by Senator Harper of the 7th. Mr. President, Senator Harper, the seventh, and others offer the following amendment number 1 to House Bill 806 by deleting line 1 and inserting in lieu thereof the following: to amend Article 10 of Chapter 21 of Title 15 of the OCGA relating to the Georgia Drivers Education Commission, so to transfer such commission from the Department of Driver Services to the Governor's Office of Highway Safety, to extend the sunset applicable to penalties for violations of traffic laws or ordinances, to amend Chapter 5, Title 40 of the OCGA, and for other purposes. Mr. President, Senator Harper, the seventh, offers the following amendment number 2 to House Bill 806 by replacing line 1 with the following: to amend Chapter 2 of Title 35 of the OCGA relating to the Department of Public Safety so as to revise provisions for the off-duty use of motor vehicles by certain law enforcement officers of the department related to approved off-duty employment, to amend Chapter 5 Title 40 of the OCGA, and for other purposes.
Is that all?
Mr. President, Senator Hufstetler, the 52nd, offers the following amendment number 3 to House Bill 806 by replacing line 1 with the following: to amend Title 25 of the OCGA relating to fire protection and safety so as to revise requirements for the issuance of certificates of compliance for fire departments, to revise and provide for definitions, to expand the functions and powers of the Georgia Firefighter Standards and Training Council, to revise qualifications for firefighters, to amend Chapter 5 Title 40 of the OCGA, and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator from the seventh. Present the bill.
Thank you, Mr. President. House Bill 806 is the Department of Driver Services annual update bill. This bill does two things. One, it moves the amount of time for a driver's license for renewal from 5 years to 8 years. And the second thing that the bill does is deals with suspension of driver's licenses and puts a sunset on that of 2 years. The purpose behind this is law enforcement agencies are supposed to turn in driver suspension information to DDS within 10 days. In some instances, that information isn't received by DDS until 10 years after such suspension was issued by a law enforcement agency. And DDS is saying that after 2 years, we're not going to do that. And that's what that particular provision is for. There are two amendments that I have offered, and I understand that there's a third amendment that will be coming. I support all three amendments. The first amendment is moving the Driver's Education Commission from the Department of Driver Services to the Governor's Office of Highway Safety. It's an administrative move. The things that are the actions that are being taken are already taking place in GOHS. This is administrative move. And the other amendment that I'm offering is a similar language to the bill, Senate Bill 404, that we've already passed out of this chamber over to the House, dealing with the Department of Public Safety and the use of motor vehicles. We fixed some things in regards to liability in Public Safety Committee. So that's what this Second Amendment does. I appreciate your support on both. Mr. President, there are no questions. I yield the will.
You do have one question. Chair recognizes Senator from the 41st.
Senator Yield.
I yield.
You mentioned two good amendments, but didn't you say there was going to be a third too? Or?
Yes, there should be a third. My understanding, there is a third amendment, and the third amendment deals with the Firefighter Standing and Training Council, and also with it deals with background checks in regards to federal law. It's an issue that we're trying to fix within our state code. It's being offered by the senator from the 52nd. I'm not sure where that's at, but my understanding is one's on the way.
Chair recognizes Senator from the 52nd.
Mr. President, I request unanimous consent to withdraw amendment number 3.
Is there objection? Without objection, the senator has that right, and the bill, the amendment will be withdrawn. Question now is on the adoption of the floor amendment authored by the senator from the 7th, amendment number 1. Is there objection? Without objection, amendment number 1 will be adopted. Now the question is on 2. Amendment number 2, is there objection? Without objection, amendment number 2 will be adopted. Now, does any other senator wish to speak for or against the bill? Is the objection agreed on the report of committee which failed to pass the bill? Chair is none. The report of committee is agreed to. Shall the main question be now put, or the objection? Chair is none. Main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. The senator from the 54th will stand by. We will be disseminating the next 8 bills that will be available to be brought off the table. There'll be a list like this coming to your desk, numbered 2. On the passage of the bill, the yeas are 47 and the nays are 2. This bill, having received constitutional majority, is therefore adopted. Chair recognizes Senator from the 54th.
Thank you, Mr. President. I ask unanimous consent to take House Bill 954 from the table.
954 from the table is the motion. Is there objection? Without objection, the bill will be removed from the table. Secretary will read House Bill 954.
House Bill 954 by Representative F. Stratton of the 104th and others, a bill to be entitled an act to amend Title 29 of the OCGA relating to guardian and ward so as to enact the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act, to provide for a short title, to provide for definitions, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate Health and Human Services recommends that this bill do pass by substitute, respectfully submitted by Senator Unterman of the 45th. Mr. President, Senate Committee on Health and Human Services offers the following substitute to House Bill 954, a bill to be entitled an act to amend Title 29 of the OCGA relating to guardian and ward so as to enact the Uniform Adult Guardianship and Conservatorship Proceedings Jurisdiction Act, and for other purposes. Mr. President, that completes the order.
Chair recognizes the distinguished senator from the 54th to present the bill. While he's coming, they're disseminating or printing right now, but HB 900, HB 1004, HB 690, HB 916, 936, 935, 960, and 818 will be next up, and they'll disseminate that momentarily.
Thank you, Mr. President. Senators, I bring before you House Bill 954. This is the Uniform Adult Guardianship and Conservatorship Proceedings Jurisdiction Act. Georgia, assuming we pass this, will become the 43rd state in the union. This is an important bill for individuals dealing particularly with senior members of their family for whom they obtain guardianship or conservatorship for. It brings us in line with the other states that participate in this system of laws associated with care for elders. I believe there is a friendly amendment from the senator from the 3rd that is in. Just clarifies some evidentiary issues when you're bringing one of these cases. Mr. President, I would yield for questions. If there are none, I ask your favorable consideration of the bill and would yield the well.
There are no questions, Senator.
Thank you, Mr. President.
Chair recognizes Senator from 32nd to speak to the bill.
Thank you, Mr. President. I'm going to vote in favor of this piece of legislation, but I want to bring everyone's attention to the fact that This is really important legislation. I believe that we should actually have a punishment provision for those that do not comply with probate court orders for guardianship and conservatorship. My father-in-law and my wife is actually the guardian for her stepfather, and routinely financial institutions choose to violate these guardianship and conservatorship orders. They need to be penalized. They need to be punished. There needs to be something out there that says they gotta comply. My probate court judge has said this is one of their #1 problems, that they don't get any recognition, any compliance, any help by the financial institutions, by some of the financial institutions in this state. That's wrong. It's got to stop, because these are people that desperately need the protection of their guardian. With that, just want to let you know we've got legislation coming in the future. Thank you.
We have a late arriving amendment. The Secretary will read the amendment.
Mr. President, Senator Ligon of the 3rd offers the following Amendment Number 1 to House Bill 954 by striking lines 109 through 112. Mr. President, that completes the order.
Chair recognizes the senator from the 1st to speak to his amendment. Third, I'm sorry, third.
Thank you, Mr. President. Lines 109 through 112 provide that a document cannot be excluded based on the best evidence rule. The amendment strikes that. We've had revisions to the evidence code that allows for certain exceptions. We need to respect those laws that are already in place. Mr. President, unless there are any questions, I'll yield the well.
Thank you. No questions, Senator. Question is on the adoption of the floor amendment authored by the senator from the 1st. Is there objection? Without objection, the amendment is adopted. Does any other, the question now is on the adoption of committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection to read and report of committee? Which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there objections? Chairs none. Main question order. Shall this bill now pass? Question on the pass the bill. All those in favor vote aye. Those opposed no. Secretary unlock the machine. On the pass of the bill, the yeas are 50 and the nays are 0. This bill, having received constitutional majority, is therefore adopted. We have some special orders. You should, all right, so y'all know which bills are coming up. All right, very good. Chair recognizes the senator from the 40th. Senator from the 40th.
Thank you, Mr. President. I move that the Senate adhere to its disagreement to the House substitute to SB 258 and a conference committee be appointed.
Read the caption.
Senate Bill 258 by Senator Miller, the 40th, and others, a bill to be entitled an act to amend Code Section 48-5-311 of the OCGA relating to creation of county boards of equalization duties, review of assessments, and appeals so as to provide that the assessed value of property for a taxable year should not be increased beyond the initial assessment value and for other purposes. Mr. President, that completes the order.
Is there objection? The senator's moving that the Senate adhere to its disagreement to the House substitute to SB 258 and and a conference committee be appointed. Is there objection? Without objection, the conference committee will be comprised of the senator from the 46th, senator from the 4th, and the senator from the 11th. Go forth and maintain the Senate position. Chair now recognizes Senator from the 46th, Distinguished Majority Leader.
Thank you, Mr. President. I move the Senate insist on its substitute to HB 205.
Moving to insist, Secretary will read.
House Bill 205 by Representative Rice in the 95th and others, a bill to be entitled an act to amend Chapter 5 of Title 40 of the OCGA relating to driver's licenses so as to require a driver who refused blood alcohol concentration testing and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, let the House know that once again the Senate has insisted on its position. Chair recognizes now the distinguished senator from the 9th.
Thank you, Mr. President. I move that the Senate insist on its amendment to HB 904.
Read the caption.
House Bill 904 by Representative Strickland of the 111th and others, a bill to be entitled an act to amend Chapter 8 of Title 34 of the OCGA relating to emergent employment security so as to change certain contribution rates and credits and for other purposes.
Is there objection? Without objection, please let the House know the Senate has insisted once again on its amendment to House Bill 904. Chair recognizes now the senator from the 7th.
Mr. President, I move that the Senate insist on its substitute to House Bill 876.
876, read the caption.
House Bill 876 by Representative Perkle, the 155th, and others, a bill to be entitled an act to amend Chapter 6 of Title 4 of the OCGA relating to livestock dealers and auctions so as to update license and surety requirements of livestock dealers and livestock market operators and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, please let the House know the Senate once again has insisted on its substitute to House Bill 876. Senator from the 40th is recognized now.
Thank you, Mr. President. I ask that HB 900 be removed from the table.
Is there objection? Without objection, the bill will be removed from the table. Secretary will read House Bill 900.
House Bill 900 by Representative Cooper, the 43rd, and others, a bill to be entitled an act to amend Part 2 of Article 2 of Chapter 13 of Title 16 of the OCGA relating to electronic database of prescription information so as to authorize the retention of database information for 2 years to provide for delegates of prescribers and dispensers to access database information under certain conditions, to revise language relating to subpoenas and search warrants to provide for accessing database information for purposes of investigation of potential abuse, to provide for the release of non-patient specific data to the Agency for Instructional Data Abuse Prevention and for other purposes. Mr. President, the Committee of the Senate on Health and Human Services recommends that this bill do pass. Effectively submitted by Senator Ungerman of the 45th. Mr. President, Senator Jeffries of the 17th and others offer the following amendment number 1 to House Bill 900 by inserting after the word liability on line 8 the following: to amend Code Section 43-34-103 of the OCGA relating to delegation of authority to physician assistant so as to authorize a physician to delegate to a physician assistant the authority to prescribe hydrocodone compound products for a 3-year period, to provide for limitation to require a report, to provide for additional continuing education requirements regarding Schedule II controlled substances, and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator on the 40th present the bill.
Thank you, Mr. President. This bill does a couple of things. It amends and allows the Georgia Drug and Narcotics Agency to retain the aggregated prescription information on Schedule 2, 3, 4, and 5 controlled substances for 2 years instead of 1. It provides for the delegation of prescribers and dispensers to get this information, and it provides the release of non-patient specific data to the Georgia Drug and Narcotics Agency for instructional, drug abuse prevention, and research purposes. I ask for your favorable consideration. While I have empathy for the amendment that is being offered, I will tell you in discussions with the medical community, this bill is very, very important. I've heard that from several of the doctor groups and prefer that this bill have no amendments added to it. I'll be happy to answer any questions if there are any. Otherwise, I will yield the will.
No questions, Senator. Chair recognizes Senator from the 17th. Senator is moving to withdraw amendment number 1. Is there objection? Without objection, amendment number 1 is withdrawn. Does any other senator wish to speak for or against the bill? Is there objection? Agree on the Board of Committee which will pass the bill? Chair is none. Board of Committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those opposed no. Secretary like the machine. On the pass of the bill, the yeas are 51 and the nays are 0. This bill, having received records constitutional majority, is therefore adopted. Chair recognizes now the senator from the 23rd.
President, I request without objection removal of HB 1004 from the table.
1004. Is there objection? Without objection, 1004 will be removed from the table and Secretary will read.
House Bill 1004 by Representative Jaspers the 11th and others, a bill to be entitled and act to amend Titles 15 and 44 of the OCGA relating to courts and property respectively, so as to provide for requirements for maps, plats, and plans to be filed for record, to provide for filing of electronic images of maps, plats, and plans, to provide for delivery of plats to the clerk of the Superior Court, to change certain provisions relating to to provide an effective date, to provide for related matters, bill convicting laws, and for other purposes. Mr. President, the Committee of the Senate on Special Judiciary recommends that this bill do pass by substitute, respectfully submitted by Senator Thompson and the fifth. Mr. President, the Senate Special Judiciary Committee offers the following substitute to House Bill 1004, a bill to be entitled and act to amend Titles 15 and 44 of the OCGA relating to courts and property respectively, so as to provide requirements and certifications for maps, plats, and plans to be filed for record, to provide for filing of electronic images of maps, plots, and plans, to provide for electronic processing by clerks of Superior Court, to provide a criminal penalty, and for other purposes. Mr. President, that completes the order. Oh, just kidding. This one's not on the desk yet. It hasn't been copied. Mr. President, Senator Gucci, the 51st, and others offer the following amendment number 1 to the Senate substitute to House Bill 1004 by inserting after the word plats on line 12 the following: to add a new tribe to be recognized by this state as a legitimate American Indian tribe, and to correct address information, and for other purposes. Mr. President, Senator Hill, the 6th, and others offer the following amendment number 2 to House Bill 1004 by inserting after the word 2 on line 1 the words amend Article 3 of Chapter 5 of Title 14 of the OCGA relating to corporations organized for religious, fraternal, or educational purposes, so as to change provisions relating to land conveyances to churches or religious societies, to provide that disputes with regard to determining the property rights, relevant matters, to provide for legislative findings, and for other purposes. Mr. President, that completes the order.
I would like to take this opportunity to welcome the daughter of the senator from the 52nd. One thing I would like to announce, however, is I saw her Sunday. She ran in the marathon, the Publix marathon, and did a wonderful, wonderful job. Very proud of her. But next time you see her when we're in session, she will be a doctor, Dr. Huffstetler, in psychology this spring. So glad to have you with us today. Appreciate it very, very much. Your father certainly will need your services, I'm confident, after this General Assembly effort. Senator from the 31st, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
I would request a ruling from the chair on germaneness of amendment number 1 to House Bill 10004. It appears that the bill is about real estate and the amendment is about the establishment of Indian tribes.
Let me look.
Sounds like terrible.
All right. We're going to have to rule it non-germane. I was trying to find a way to help the senator from the 51st, but that was a stretch. But it also makes number 2 not germane as well. So, questions on the adoption of the, or excuse me, Chair recognizes now Senator from 23rd.
Thank you, Mr. President. Fellow senators, this bill has nothing to do with Indians, nothing to do with churches, but it does have something to do with efficient operation of our clerk's offices, instituting electronic filing for plats. They are set up to receive them. There are no additional court costs. This standardizes the format in which plats are filed, and there'll be public access at the clerk's office, as it always has been, and you'll have access from your office to view plats. If there are no questions, I yield the well and urge your favorable consideration of HB 1004.
Is there objection to adoption of committee substitute? Chair hears none. Committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed in report of committee which fail pass the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question is, pass the bill. All those in favor vote aye. Those opposed no. Secretary will unlock the machine. Senator from the 7th will stand by.
Outside. Why is mine non-germane? Property. Property? Yeah, I mean, real estate.
But I thought they were going to put it on over there.
There are, but I just wanted to, be sure. But this was, we made that amendment so that it was going to go into property code.
On the passage of the bill, the yeas are 51, the nays are 0. This bill, MC Rex constitutional majority, is therefore adopted. Chair recognizes Senator from the 7th.
Mr. President, I ask unanimous consent to remove House Bill 690 off the table.
690 is the objection. Without objection, 690 will be removed from the table. Secretary will read 690. Straight out.
House Bill 690 by Representative Carter of the 175th, the bill to be entitled an act to amend Part 5 of Article 8 of Chapter 2 of Title 47 of the OCGA relating to membership of certain law enforcement officers in the Employees Retirement System of Georgia, so as to provide that certain law enforcement officers may obtain credible service in such retirement system under certain conditions, to define a current certain term, to provide for the payment of the value of obtaining such credible service, to provide for application, to provide for related matters, to provide conditions for an effective date and automatic repeal, to repeal convicting laws, and for other purposes. Mr. President, the Committee of the Senate on Retirement recommends that this bill do pass. Publicly submitted by Senator Huffstadler, 52nd. Mr. President, that completes the order.
Chair recognizes Senator from the 7th to present the bill.
Thank you, Mr. President. House Bill 690 is not a bill that just rural Georgia, so you urbanites can vote for this particular underlying bill, and I'd appreciate your support. But it is a pro-law enforcement bill, members of the Senate, and it doesn't just affect those in the hinterlands. What it does is it allows law enforcement officers that work for the state of Georgia to buy up to 5 years of credible service if they've been a member of our retirement system for at least 10 years, were not a member of a retirement system at their local, certain retirement systems at their local agencies, and they had vested police powers during that service. Mr. President, if there are no questions, I will yield the will. There is no cost to the state, no actuarial cost to the state. The cost is on the backs of the officers that wish to buy the credible service. Mr. President, if there are no questions, I'll yield the will.
Does any other senator wish to speak for or against the bill? Is the objection agreed, report of committee which fail, pass the bill? Chair is none, report of committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none, main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill vote aye. Those opposed, no. Secretary, unlock the machine. Chair recognizes on the passage of the vote, the bill, the yeas are 51, the nays are 0, and this bill, Amnesty Rex Constitutional majority, is therefore adopted. Chair recognizes the senator from the 6th. Or no, I'm sorry. Chair recognizes Senator from the 54th.
Thank you, Mr. President. I ask unanimous consent to remove House Bill 916 from the table.
916. Is there objection? Without objection, 916 will be removed from the table. Secretary will read House Bill 916.
House Bill 916 by Representative Hightower, the 68th, and others, a bill to be entitled an act to amend Code Section 26-4-118 of the OCGA relating to the Pharmacy Audit Bill of Rights so as to remove an exception relating to certain audits conducted by the Department of Community Health to amend Article 7 of Chapter 4 of Title 49 of the OCGA relating to medical assistance journal issues to provide the clerical or other errors and for other purposes. Mr. President, the Committee of Senate Health and Human Services recommends that this bill do pass, respectfully submitted by Senator Ungerman of the 45th. Mr. President, that completes the order.
Senator from the 30th approach. Chair recognizes Senator from 54.
Thank you, Mr. President. Senators, I bring before you House Bill 916, which is an amendment to the Pharmacy Audit Bill of Rights. This bill is in the same form that passed the House unanimously. Essentially, what it allows is for providers, health providers to the DCH, if they have a clerical or administrative error in their billing, it prevents them from being cut out of being reimbursed altogether. So that the current state of affairs is you do the work. If there's a clerical error, you didn't dot your I or didn't cross your T, you end up with nothing. It does allow if there's an overpayment, obviously, for recoupment, but if it's only a clerical error, you are able to get paid if that error is corrected, and you have a 30-day period to accomplish that. Mr. President, I yield for questions. If there are none, I'd ask your favorable consideration of the bill and yield the well.
No questions.
Thank you, Mr. President.
Does any other senator wish to speak for or against the bill? Is there objection? Agree in the Porter Committee which fair will pass the bill. Chair is none. Porter Committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question order. Shall this bill now pass? Question on the passage of the bill. All those in favor of the bill vote aye. Those opposed no. Secretary unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1, and this bill, MC Rex constitutional majority, is therefore passed. Chair recognizes now Senator from the 6th.
Thank you, Mr. President. I ask for unanimous consent to remove House Bill 936 from the table.
Removing from the table 936. Is there objection? Without objection, 936 will be removed from the table. Secretary will read.
House Bill 936 by Representative Harrell of the 106th and others, a bill to be entitled an act to amend Article 2, Chapter 7 of Title 48 of the OCGA relating to the imposition rate, consumption, and exemptions from income taxes so as to clarify certain terms in respect to the wages necessary to qualify for a jobs tax credit to provide for related matters to repeal conflicting laws and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill do pass by substitute. Respectfully submitted by Senator Hill of 32nd. Mr. President, the Senate Committee on Finance offers the following substitute to House Bill 936, a bill to be entitled an act to amend Article 2 of Chapter 7 of Title 48 of the OCGA related to the imposition rate and exceptions from income taxes so as to provide for an income tax credit for members of the Georgia State Defense Force and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator from the 6th. Present the bill. Senator from the 51st approach.
Thank you, Mr. President. I bring before you House Bill 936. And this bill simply makes language consistent throughout this section for wage requirements in order to be eligible for statutory job tax credits in opportunity zones. I think it's really a great measure because it tightens up the bill. We're currently able to offer tax credits that takes into account the aggregate total of the job costs. In other words, if you had a threshold of $100,000, then you could take a bunch of high-paying jobs and then a bunch of low-paying jobs and aggregate them out and pass the test. Well, this bill changes it so each job has to be above a certain threshold, and so each job is taken into account instead of an average, which means that more high-paying jobs will be offered in the tax credit. It's a good measure, and I ask for your favorable consideration. There was also put in here a Georgia State Defense Force tax credit. This is an all-volunteer force. They help our National Guard. It's an all-civilian force as well. And so we've done a lot of great things for veterans and members of the National Guard, but this is a tax credit for State Defense Force, $500 per year. If there are no questions, I'll yield the well.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Green report of committee. Which favor will pass the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put? All those in favor vote aye. Those opposed no. Secretary, unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having Series constitutional majority, is therefore adopted. Chair recognizes Senator on the 51st.
Mr. President, I ask for unanimous consent to remove House Bill 935 from the table.
Is there objection? Without objection, 935 will be removed from the table. Secretary will read.
House Bill 935 by Representative Harold, 106 and others, a bill to be entitled an act to amend Part 1 of Article 2 of Chapter 5 of Title 48 of the OCGA relating to exemptions from ad valorem tax so as to add certain fulfillment centers to properties eligible for a free port exemption derived related matters, repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill do pass. Respectfully submitted by Senator Hill, the 32nd. Mr. President, that completes the order.
Chair recognizes Senator 51st.
Senators, this is a good economic development bill. I think you'll be happy to vote for it. It simply creates a new type of free port exemption from ad valorem taxes for e-fulfillment or e-commerce centers in Georgia. It's an option for local governments. They can choose it if they wish. Mr. President, I'll yield for any questions.
You do have a question. Chair recognizes Senator 23rd for a question.
Mr. President, will the senator yield?
I will.
What's a fulfillment center?
A fulfillment center is defined, and let me read it to you. Let me have my bill here. It's basically where goods are shipped in and out of a business, like a warehouse or a center, but there's no retail site on the premises, and those orders are taken over the internet or by phone. That's all. No retail site on the premises.
Chair recognizes Senator in the 41st for a question.
Senator Yield?
Yes, sir.
Are there any present such facilities that will accrue a tax benefit, and do you know what that would cost local governments or the state?
The Freeport exemptions are already in Georgia. Almost every county, not every county, but almost every county in Georgia has the option of putting the Freeport exemption on the ballot for their local citizens to elect to offer that for incentives to get companies to move there. This new definition to allow these fulfillment centers will also be an option that the local governments will have to choose whether they want to include them in their Freeport exemption ordinances or not. So the impact to the local government is zero unless the local governments decide to offer these, which if you don't have a fulfillment center today and you offer this Freeport exemption and you get a fulfillment center, then that's good for job creation and also for other ad valorem tax purposes. So I would say it's a good thing for everybody. Thank you. Appreciate it.
Does any other senator wish to speak for or against the bill? Is there objection? Agreed to report of committee which failed to pass the bill. The chair's non-reported committee is agreed to. All those in favor of the bill vote aye. Those opposed no. Secretary, unlock the machine. On the passage of the bill, the yeas are 53, the nays are 1. This bill, having received requisite constitutional majority, is therefore adopted. Got a couple of special orders now. Chair recognizes Senator from the 17th.
Move that the Senate disagree to the House substitute to Senate Bill 199.
Read the caption.
Senate Bill 199 by Senator Jeffries of the 17th and others, a bill to be entitled an act to amend Chapter 2 of Title 21 of the OCGA relating to primaries and elections generally so as to provide a definition to prohibit certain activities within close proximity to polling places, to provide for related matters, and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, let it go forth that the Senate has disagreed to the House. Chair recognizes the senator from the 52nd.
Mr. President, I move that the Senate adhere to its disagreement to the House substitute to Senate Bill 64 and that a conference committee be appointed.
Read the caption.
Senate Bill 64 by Senator Hufstedler, 52nd, and others, a bill to be entitled an act to amend Code Section 15-11-2, Title 19, and Chapter 10 of Title 31 of the OCGA relating to definitions of the juvenile code, domestic relations, and vital records respectively, so as to repeal voluntary acknowledgments of legitimation, to provide for related matters and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, the conference committee will be comprised of the senator from the 10th, senator from the 14th, and the senator from the 52nd. Now, the chair recognizes senator from the 48th.
Mr. President, I ask unanimous consent to remove House Bill 960 from the table.
960, is there objection? Without objection, 960 be removed from the table. Secretary will read the caption.
House Bill 960 by Representative Kelly of the 16th and others, a bill to be entitled an act to amend Chapter 2 of Title 48 of the OCG or the State Administration and Collection of Revenue so as to provide for confidentiality of certain tax information, provide for an interest rate on delinquent payments that adjust to reflect changes in the prime rates, to adjust the penalties for non-payment of ad valorem taxes to offset the reduction in interest rate and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill be passed by substitute by Senator Hill of the 32nd. Mr. President, Senate Committee on Finance offers the following substitute to House Bill 960, a bill to be entitled an act to amend Chapter 2 of Title 48 of the OCG of the State Administration and Collection of Revenues is derived for confidentiality of certain tax information and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator 48.
Mr. President, ladies and gentlemen of the Senate, it's my privilege to present House Bill 960, a bill that deals with issues arising from a substantial refund of overpaid sales taxes that affected a community in northwest Georgia. This bill has procedures dealing with notification of affected communities, protecting confidentiality, adjusting interest rates and penalties, and other measures to make those distributions equitable. This bill was very carefully considered by the Senate Finance Committee and carries a due pass recommendation. I urge your favorable consideration of the legislation, and if there are no questions, I will yield the well.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? All those in favor of the bill vote aye. Those opposed, no. Secretary, unlock the machine. Senator from the 54th will stand by. On the passage of the bill, the yeas are 54, the nays are 0. This bill, MC Rex constitutional majority, is therefore passed. Chair recognizes Senator from the 54th.
Thank you, Mr. President. I ask unanimous consent to take House Bill 818 from the table.
Is there objection? Without objection, House Bill 818 will be removed from the table. Secretary will read House Bill 818.
House Bill 818 by Representative Shaw of the 176th and others, a bill to be entitled an act to amend Chapter 9 of Title 34 of the OCGA relating to workers' compensation to change certain provisions relating to workers' compensation insurance, awards, benefits, and administration to provide that administrative law judges are subject to the Georgia Code of Judicial Conduct and for other purposes. Mr. President, the Committee in the Senate on Insurance and Labor recommends that this bill do pass by Senator Bethel of the 54th. Mr. President, Senator McCune of the 29th offers the following amendment number 1 to House Bill 818 by deleting lines 1 and 2 and inserting a lieu thereof the following: to amend Title 34 of the OCGA relating to labor and industrial relations so as to change certain provisions relating to employment, to change certain provisions of a definition in order to provide that services performed by an individual for wages shall be deemed to be in employment unless the Department of Labor makes a contrary determination based upon evidence submitted to certain factors determining that such individual has been and will continue to be free from control of direction over the performance of such services and for other purposes. Mr. President, Senator Hill, the 32nd, offers the following amendment number 2 to House Bill 818 by inserting after the word 2 on line 1 the words, amend Article 1 of Chapter 9 of Title 34 of the OCGA relating to workers' compensation generally so as to provide for a certification of state law applicability to be issued by the State Board of Workers' Compensation under certain circumstances, to provide for an application fee, to authorize the board to promulgate certain rules and regulations, and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator 54th.
Thank you, Mr. President. Senators, I bring before you House Bill 818. It is the product of the Georgia Workers' Compensation Advisory Council. On an annual basis, we try to keep our workers' compensation law up to date and current. In particular, this year, after a few years without, there is an adjustment in the average weekly wage, an upward adjustment in the average weekly wage. That is something we try to keep up with, the current averages and trends across the state, and it is supported by all interested parties in the business community in particular. I'm going to ask your favorable consideration of 818. Mr. Chair, when I reach my, Mr. President, when I reach my seat, I'm going to ask for a germaneness ruling on Amendment 1. If it is ruled germane, I'm going to ask for you to vote it down, as it is not really related to workers' compensation, and the council's work, I think, ought to be respected. I'm also going to ask for a no vote on Amendment 2. This is a delicate process where employers and claimants, attorneys, and all interested parties work together throughout the year to come up with a bill that is consensus, and I'd like to protect that process as we have done historically in Georgia. Mr. President, I yield for questions. If there are none, I would yield the well.
There are no questions, Senator. Chair recognizes Senator 54th.
Thank you, Mr. President. I ask the chair for a ruling on the germaneness of Amendment 1.
Yeah, it's not germane.
Thank you, Mr. President.
All right, the question, or Senator from the 32nd is recognized to speak to his amendment.
Thank you, Mr. President. It may just be speaking to the bill, depends on this germaneness. Here's the issue. You cannot introduce legislation in the state of Georgia related to workers' compensation unless you go before the almighty Workers' Compensation Board and get their permission. They have to pre-approve everything that we do in this state related to workers' comp. They have to pre-approve. So that means you don't have the right to represent your constituents. My amendment is brought to you because of a constituent. Most people don't know that in the state of Georgia today, we have a tax on small businesses for workers' comp. If you have 3 or fewer employees and do not do any construction work, you don't have to have workers' compensation coverage. However, there's nothing that states that other than that fact in the law. So a lot of businesses are requiring you have workers' compensation coverage when they're called ghost policies. A ghost policy means you spend $1,000, $2,000 a year for nothing whatsoever. They actually tell you this doesn't, you have no claim, you can never file a claim. It's like spending all this money for health insurance and you never have the right under the law to file a claim. But they'll go collect it because they want to collect the premiums and they want to collect the commissions. This came to me because of a constituent. A constituent brought this to me. I was aware of it for a while, but I brought it to you because of a constituent. Florida and some other states have an exemption certificate. So it says you don't have to have workers' compensation coverage because the law says that. It proves a negative. And if you ever qualify under the law, then you actually get workers' compensation coverage. So I introduced Senate Bill 338 this year. 338, it's an existing bill, never has had a hearing because we went before the Workers' Compensation Board August, September, October, November, December of last year, and they said, oh no, we want to take your premiums from you and continue to tax the small businesses of this state. I believe it's wrong. I believe it's wrong. That's the purpose of this amendment, to continue to move this forward. And if you ever qualify under the law for workers' comp coverage, then you got to go get it. My 16-year-old didn't have automobile insurance until she turned 16. So we're not saying you don't have to. We're just saying if the law didn't require you. So I think it's a burden. I think it's a tax. I understand the ruling of the president. I believe it's wrong that you have to go and kneel before the workers' compensation policy group before you have the right to actually have a hearing in the state. And with that, I would love to have your support for it. The underlying bill is needed. My desire is not to corrupt that. My desire is to stand up for the constituents of our state and your districts as well. Thank you, Mr. President.
You do have a question. Chair recognizes Senator from the 9th for a question.
Thank you, Mr. President. Does the Senator yield?
I do.
Would this certificate satisfy contractual requirements that maybe a contractor or business owner may have?
Yes.
So having this would satisfy a contract that they have with another, someone
yes.
either they're working for or something?
You get these you get publicly traded companies that they have a clerk basically that says, we got to check off the box that you have a certificate of insurance. They're not going to go research the law, and they don't. And so other states have a certificate of exemption is what it is. That checks the box off and you move forward. But right now, there are many of us paying thousands of dollars a year, not thousands and thousands, but quite a bit of money a year. And your agent will tell you you'll never have the right to file a claim because you have a dummy or a ghost policy. It's a frivolous policy, but they do it so you can satisfy something. And I think it's wrong.
But isn't it also true, though, that you can have one employee or two employees and that they may not be receiving the workers' comp protection, and if you're working on a larger job, those folks will be going without coverage. Is that not true?
That is not true. The law today in the state of Georgia says if you have 3 or more, you have to have coverage. I'm just following the law. 3 or more, and you can't be in construction. You can't have LLCs and all these it's just you as a sole practitioner, basically, a consultant. So if you fall into the area of the law that is mandated to have coverage, I would say follow the law. I advocate you do, strongly. But these people follow in the exception, and I'm here to help the little guys, and that's why I'm here.
So you're saying if they have, will you further yield?
I do, but I know we're short of hours.
I understand.
You can tell
I
I'm
understand, but
passionate about it, but I don't want to.
But I'm trying to understand. So if an employer does have one employee, they could still apply for this, or you're saying they do not?
Under Georgia law, if you have one employee, you're not required to have workers' comp coverage today. If we need to change that, I'll be the second co-sponsor on your bill. Today, you are not required under your scenario to have workers' comp coverage. And that's fine. I'm just saying we should have a certificate that's allowed so you're not taxed in the state for something that you get no benefit for. Thank you very much for listening to
you have more questions if you...
Mr. President, I think you ruled this non-germane a few minutes ago. Did you or not?
Well, it was the other one that was not germane. I hadn't ruled on this one.
I think this is germane, but I'll be happy to take a question. One more, and then I'll apologize.
Chair recognizes Senator from 16.
Senator Yield?
Yes, sir.
These ghost policies that are into effect, what provision does your bill make for a person who have laborers? Are they bring in an occasional laborer? Does this bill make any provision for coverage for them? I hire you as the contractor to do the job without workers' compensation, but you hire a part-time employee and he's hurt on the job. That's where the workers' comp policy would pick in that he would have. How does this apply to the contractor that is hiring him?
To my knowledge, your scenario would require workers' compensation coverage today. Would it not? I can't ask the questions, but I believe your scenario would require coverage. Thus, this provision would not apply. If you're required under the law to have coverage, then please go get it. Please follow the law. This is a narrow exception, usually for one-person companies, not in construction and not in all these other scenarios. This just is a tightly defined rifle shot. So if you're exempt, this is just a certificate. It's $25. The state of Georgia is not mandated or required to investigate because you're not doing that today. Keep in mind, you're not getting coverage today. unless some company says do it, and then the insurance companies or I think taxing us unfairly. And they want to stop the legislation.
Does your amendment specifically exclude construction?
Yes.
Does? Okay. Thank you.
Thank you, Mr. President. I will yield the well. And I commend to you Amendment number 1 on behalf of the micro businesses across our state and in your districts. Thank you.
Senator has yielded. Chair recognizes Senator from 54th close the debate.
Thank you, Mr. President. Just to reiterate, I didn't ask for a germaneness ruling on Amendment 2 because it is germane. I just asked that you oppose it. Contrary to what the Senator from 32nd said, it's not the State Board of Workers' Comp. It is the Georgia Workers' Compensation Advisory Council. The State Board does have a voice on that council, as do claimants' lawyers, as do employers, and it is a comprehensive group. We've asked them, I have asked them to look at this issue. I think they have a good faith opportunity to do that. I will point out that this does not authorize the State Board of Workers' Comp to communicate with the Department of Labor or the Department of Revenue to do any due diligence whatsoever to determine whether the representation is or is not true. That would be a basic minimum requirement if we were going to authorize this, so that they would not be just simply saying, well, you say you're less than 3, so here's your certificate. We need to do this in an appropriate way. We have a very, very successful workers' comp program in the state of Georgia. Warts and all, it is a really good system, and many states admire what we do. We do not need to be careless. We are 343 on day 40. Doing this today is final passage. Making an amendment means we're back and forth. I ask that you vote down Amendment 2, and I ask that you support the bill. Thank you, Mr. President. I yield the well.
Okay, we're now in Amendment 2. Is there objection to Amendment number 2? There is objection by the Senator from the 54th. Senator from the 29th, what purpose you rise?
Mr. President, I move the ayes and nays.
Ayes and nays on Amendment number 2. Shall the ayes and nays be sustained? Hold on, 1, 2, 3, 4, 5. There's 5. Okay, we have 5. All those in favor of Amendment number 2 will vote aye. Those opposed, no. Secretary, unlock the machine. Amendment 2. Man, it looks like that one just got ruled non-germane. I should have asked for that. On the adoption of the amendment, the yeas are 10 and the nays are 43, and the amendment has lost. Now, does any other senator wish to speak for or against the bill? Is there objection? Agree and report to committee which fail pass the bill. Chairs none. Report to committee is agreed to. All those in favor of the bill vote aye. Those opposed no. Secretary, unlock the machine. You will be getting the third tranche of bills that are eligible. On the pass of the bill, the yeas are 49, the nays are 1. This bill having Rex constitutional majority is therefore adopted. Moving on to the next group. Chair recognizes Senator from the 15th. 821.
Which one? 654, right?
821. 821.
Thank you, Mr. President. I move that we remove House Bill 821 from the table.
Is there objection? Without objection, the House Bill 821 will be removed from the table. Secretary will read.
House Bill 821 by Representative Williams of the 168th and others, a bill to be entitled an act to amend Chapter 1 of Title 43 of the OCGA relating general provisions applicable to professions and businesses so as to require professional licensing boards and other boards to adopt rules and regulations implementing a process by which military spouses and service members may qualify for temporary licenses, licenses by endorsement, expenditure licenses, or combination thereof for each profession, business, or trade for which a license is issued, to provide for a short title, to provide for related matters, repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Regulated Industries and Utilities recommends that this bill do pass by consent by Senator Jeffries of the 17th. Mr. President, that completes the order.
Chair recognizes Senator the 15th to present the bill.
Thank you, Mr. President. This is a good bill for our veterans. All this bill does is require a professional licensing board to adopt rules and regulations that would implement a process by which military spouses and transitioning service members may qualify for temporary licenses by endorsement and/or expedited license for each professional business or trade which a license is issued in the state of Georgia, and I emphasize temporary. The deadline to adopt such rules and regulations is July 1st. If there are no questions, Mr. President, I'll yield the well or I'll stand by for questions.
There are no questions, Senator. You
Thank
did
you, Mr. President.
Excellent job, as you always do. Does any other senator wish to speak for or against the bill? Is there objection? Agree to report of committee which failed to pass the bill. Chair is none. Report of committee is agreed to. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Senator from the 52nd will stand by. You will be next. On the passage of the bill, the yeas are 53, the nays are 0. This bill, MC Rex constitutional majority, is therefore adopted. Chair recognizes Senator from the 52nd.
Mr. President, I request unanimous consent to remove House Bill 783 from the table.
783, is there objection? Without objection, 783 will be removed from the table. Secretary will read House Bill 783.
House Bill 783 by Representative Broderick of the 4th and others, a bill to be entitled an act to amend Chapter 13 of Title 16 of the OCGA relating to controlled substances to change certain provisions relating to Schedule 1 and Schedule 4 controlled substances, to change certain provisions relating to the definition of dangerous drug, provide for restricted dangerous drugs, provide for penalties, and for other purposes. Mr. President, the Committee of the Senate on Judiciary and Non-Civil recommends that this bill be passed by substitute. Mr. President, the Senate Judiciary and Non-Civil Committee offers the following substitute to House Bill 783, a bill to be entitled an act to amend Article 8 of Chapter 12 of Chapter 13 of Title 16 of the OCGA relating to regulation of low THC oil and controlled substances, respectively, so as to change the definition of low THC oil, to change certain provisions relating to Schedule 1 and Schedule 4 controlled substances, and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator from 52nd.
Thank you, Mr. President. This bill is our annual drug update bill. Since we don't have a pharmacist here anymore, I've been elected to carry this, but we do this every year. It lists those restricted dangerous drugs. We've had to add different salts that are used for synthetic marijuana. They change the combinations, and we have to keep updating that each year. It also, we had a bill that passed with a 3% THC level a couple of years ago, 5% last year. This sets in code that low THC would be 5%, which makes it uniform with what we have passed in the past. It's the routine annual update, and if there's no questions, Mr. President, I'll yield the well.
No questions, Senator. Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Green report committee wish to favor pass the bill. All those in favor of the bill vote aye. Those opposed no. Secretary elect machine. On the chair, senator from the 13th will be next, then the senator from the 40th. On the passage of the bill, the yeas are 52, the nays are 1, and this bill having serious constitutional majority is therefore adopted. Chair recognizes Senator 13th.
Thank you, Mr. President. I ask unanimous consent to remove House Bill 212 from the table.
212, is there objection? Without objection, 212 will be removed from the table. Secretary will read House Bill 212.
House Bill 212 by Representative Walden of the 3rd and others, a bill to be entitled an act to amend Code Section 43-34-283 of the OCGA relating to licensure requirements for pain management clinics so as to revise the provision relating to healthcare professionals who must be on site at a pain management clinic in order for the clinic to provide medical treatment or services to repeal conflicting laws and for other purposes. Mr. President, the Committee of Senate on Health and Human Services recommends that this bill be passed by substitute, respectfully submitted by Senator Unchman, the 45th.
Chair recognizes Senator 45th. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
I realize that House Bill 212 is up and there's an amendment number 2 on our desk, but not an amendment number 1.
I believe amendment number 1 is in the book.
Oh, okay.
In your book.
Thank you. I appreciate it.
Mr. President, Senate Committee on Health and Human Services offers the following substitute House Bill 212, a bill to be entitled an act to amend Code Section 43-34-283 of the OCG relating to license requirements of pain management clinics to supervise the provision relating to the healthcare professionals who must be on site at a pain management clinic in order for the clinic to provide medical treatment or services, to repeal convicting laws and for other purposes. Mr. President, Senator Hill, the 32nd, offers the following amendment number 1 to House Bill 212 by inserting after the word 2 on line 1, the words amend Article 2 of Chapter 34 of Title 43 of the OCG relating to medical practice relative to physicians, assistants, and others so as to provide for certain requirements for advertisement or publication, representation, and board certification by physicians and for other purposes. Mr. President, Senator Cowser, the 46th, offers the following amendment number 2 to House Bill 212 by striking lines 17 and 18 and inserting in lieu thereof the following: administration of anesthesia by a certified registered nurse anesthetist pursuant to a physician's order under the direction and responsibility of a duly licensed physician who is on site at the pain management clinic and for other purposes. Mr. President, that completes the order.
Chair recognizes Senator 13th. Present the bill.
Yes, you do. Excuse me. Thank you, Mr. President, and thank you, everyone in the Senate. I present to you today House Bill 212, and this is a bill that there were some changes a couple of years ago, and the certified registered nurse anesthetists were left out of the bill. So this was a cleanup bill to add them back into this. There's legal language. We worked with the Attorney General's office on this bill. They were in our committee meeting. They were in agreement to this bill. There are two amendments to this bill. The first one, the first one is by the senator from the 32nd, and he's going to withdraw that one. But the second one is by the senator from the 46th, and I would ask that you not support the amendment to this bill, and here are some of my rationale. This amendment would dictate how the physician runs his practice. Secondly, currently PAs can do what this amendment says they don't want the CRNAs to be able to do. Thirdly, this amendment is a scope of practice issue. We discussed this in the Health and Human Services Committee. It was determined this is a scope of practice issue and it needs to be dealt separately. So I would urge you, members of the Senate, to please not support this amendment. Thank you. Mr. President, I'll yield the well if there are no questions.
No question. Chair, no questions, Senator.
Thank you.
Chair recognizes Senator 32nd.
Mr. President, this is the appropriate time. I ask for unanimous consent to withdraw amendment number 1.
Always a perfect time to withdraw an amendment. Is there objection? Without objection, the amendment will be withdrawn. Chair recognizes Senator from the 46th speak to his amendment.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I rise to speak to Amendment 1. Let me simplify what this amendment does. It says that in the pain clinic setting, if a certified registered nurse anesthetist is going to be administering anesthesia, there must be a duly licensed physician on the premises. Now, we are talking about invasive procedures here, putting anesthesia in your veins, even doing nerve blocks in your back where your spinal cord is involved, can result in serious injury, paralysis, death in these circumstances, and you need to protect these patients so that there is a doctor on the premises. There is a letter on your desk from a pain physician that very clearly says it supports this amendment. The way these legitimate pain doctors handle things now is they don't let their nurse anesthetists handle these procedures without them being on the premises. We owe this to the people of Georgia to do what the doctors in this field themselves recommend. You have also just heard that the Attorney General was okay with this bill in committee. I commend you on your desk a letter from Sam Olens, our Attorney General, dated today, that supports this amendment And the letter says that he has previously voiced concern regarding House Bill 212. He says that this undermines the state's ability to shut down pill mills. He strongly opposed that version of House Bill 212. That's the version before you, and has worked with members of the Senate Health and Human Services Committee to craft language that ameliorated some of his concerns. He has not, however, endorsed any version of House Bill 212 and has reiterated this time and time again how important this is for our ability to shut down these pill mills. We have an epidemic problem in this state with abuse of opioids. He goes on to say he's going to stay out of the scope of practice area, but I support your proposed amendment to HB 212. This amendment will, without question, better protect the state's ability to shut down pill mills. For those reasons, I ask that you support this amendment to protect the patients of the state of Georgia. The only other argument I have heard in favor of the bill without the amendment is it gives more health care to rural Georgia. I spoke in the hall this morning with a pain doc that says there are 30 of these clinics throughout rural Georgia, and the doctors that run them love them because they have a ready supply of patients. They may not be there every day, but they'll go down 1 or 2 days each week and be the doctor in the facility to oversee the prescription of these medications and these procedures that the CRNAs would like to do. This is not a problem with people getting treatment. It's a problem, though, for them getting quality treatment, and this amendment makes certain that they are treated in a safe manner. I would be happy to answer any questions there may be. Otherwise, I would yield the well and urge your support to Amendment 2.
You do have a number of questions. Chair recognizes Senator 13 for a question.
Thank you, Mr. President. Would the senator yield?
I yield.
Senator, would this amendment increase the cost of health care or reduce the cost of health care?
I don't see where it makes any difference whatsoever. According to the pain docs themselves, the nurse anesthetist is there participating in their surgical procedures when they're there doing them. I don't see where you knock anything off.
So the physician's somewhere else doing whatever he or she is doing, and the certified nurse anesthetist is there providing this service. That's going to lower the cost of health care.
I have never heard any dollar amounts of what this costs. What I'm worried about is protecting these patients from emergency situations that may arise and no doctor even being in the building. It's inconceivable to me that anybody would ask for this when they're not doing it. The pain doctors don't want to do it.
Okay. Would the senator further yield?
I'll be glad to yield to you.
Do you think, you mentioned rural Georgia, and I'm from rural Georgia, and you mentioned some of these pain clinics are in rural Georgia. So do you think that people in rural Georgia then should go to Augusta or Savannah, or Macon?
I'm telling you, we got 30 of them around South Georgia. When we passed this pain clinic bill, the pill mill bill, it was because they were up in Chickamauga, they were down near Valdosta, they were over near Columbus. They were people coming in from out of state. So a lot of them are outside of Metro Atlanta to make these drugs available to people, and especially folks coming in from out of state to get them, because we weren't regulating them like other states. This is a piece of the law that regulated it, and we're now undoing it.
Okay. And one last question, would the senator continue to yield? Wasn't the Attorney General, wasn't someone from his office at our committee meeting, and did they not say they agreed with what we passed in committee?
No, they said they agreed with the amendment because it made it better. It ameliorated some of their concerns. Their attorney was standing behind me during that meeting and telling me, we don't like this bill, but do what you can to help it. I never heard them come testify for the bill and say, we love this bill the way it is. And this letter is unequivocal from the Attorney General. They do not support this bill. They do support this amendment.
Yeah.
And I ask you to take that into account as we're passing legislation.
Okay, well, and I'll tell you, being part of the discussions with all the groups, that they did tell me point blank they were okay with the bills presented.
I'm not questioning your integrity whatsoever, Senator. You know what a high respect I have for you.
Chair recognizes him the 18th for a question.
Thank you, Mr. President. Does the senator yield?
I'll be glad to yield to you, Senator.
Senator, I think you've done a good job explaining the importance of this. And one of the questions you got was on the cost increased cost of this, would it also not be true that there are numerous kinds of costs, such as the cost of improper supervision and what can happen when things don't go right?
Exactly the concern some of these doctors themselves are expressing.
Senator, further yield.
Yes, I will.
Senator, you referenced that there was a paper on our, or a letter on our desk from a doctor who supported your amendment. Does in fact not that letter from the doctor, is it not just from him, but does he also not speak on behalf of the Georgia Society of Interventional Pain Physicians?
Yes, this gentleman, Dr. Giron, was the former executive director, and it is on the stationery of the Society of Interventional Pain Physicians.
One further question.
That's a good point, that this is their entire organization supports this amendment.
One further, Senator, is it not true that I support your amendment?
Absolutely, and I'm grateful for your support in looking after the people of Georgia.
Thank you.
Chair can I, Senator from the 40th.
As my good friend yields.
I'll be glad to, Senator.
Is it not true that I raised the issue about a doctor not being on site in our committee meeting?
You're the one that actually brought it to our attention in the committee meeting, so I'm glad to have your support for this amendment, Senator.
Is it further not true that after the hearing, I met with several of these certified registered nurse, anesthetic, whatever? Okay.
I can't say it either. I understand,
okay.
And I know they want this because it allows them to make more money.
But is it not true that at the present time they are performing this function?
Apparently not under the control of reputable pain intervention doctors. I don't know if they're doing it on the side, and I don't think their scope of practice statute is clear. I think it's ambiguous as to whether they should. Some of them are pushing to do that, and that's why they want to justify it in this code section, at least in the context of pain clinics, which is the area they should at least be allowed to be operating unsupervised.
Will you further yield?
Be glad to.
Is it not true that I agree that we probably need to look at the scope of practice, but neither you or myself really knows whether these people are sufficiently trained in order to do this at this point in time?
Exactly, and that's the concern. Since we don't know if these people are able to do these things in a safe manner, let's make sure there's a physician on site if we're going to be allowing them to do it. This bill will allow them to do it.
One final question.
But it makes them, a doctor be there with them so we can protect these patients.
One final question.
Be glad to yield to you, Senator.
And perhaps this appears to me to be one of the Attorney General's usual nebulous opinions, because I can't...
This is unequivocal.
Would you bear with me?
Yeah, I'll be glad to.
I'm reading the sentences. The amendment will, without question, better protect the state's ability to shut down pill mills. Now, somebody tell me that how this amendment gives them any greater ability to shut down a pill mill. Because I don't know, by somebody else given a shot.
Here's how.
Because there's
they
no
prosecute the doctors, and if the doctor's not there doing it, the doctor says, "Oh, some nurse anesthetist did this. You don't hold me responsible. I wasn't even there." But if he's there, like this bill requires, and you didn't finish that sentence, by the way, Senator. You stopped at "however." The remainder is, "I support your proposed amendment to House Bill 212. The amendment will, without question, better protect the state's ability to shut down pill." There is nothing nebulous or ambiguous about this whatsoever.
I think I'm right. Anybody that's working on that premises is automatically under that doctor's, and the doctor's ultimately responsible anyway. So I can't understand how this amendment...
the owner is. For the doctor to be responsible, the doctor has to be there. You can't put a man in jail for something he's not even aware of happening.
With all due respect, I don't think that interpretation's right.
Well, it depends. I guess you can either agree with the Attorney General or not. He put it in writing for us.
Chair will remind the members of the body that when you rise for the purpose of asking a question, you should confine your remarks to asking questions. Senator from the 39th District is recognized for the purpose of asking a question.
Will the senator yield?
I'll be happy to yield to the whip.
I have a question just for my edification. What kind of procedures are we talking about? Are we talking about invasive procedures? Just exactly what is the spectrum of procedures, if you don't mind telling us that?
The doctors that I have spoken with are talking about invasive procedures where you administer anesthesia intravenously or even into the spinal cord itself, like an epidural type injection, nerve block type thing. So these are not, here's a pain pill, good luck to you. These are in the practice of these interventional pain doctors, the doctor is participating and the nurse is assisting them side by side. Thank you.
No further questions, Senator. The
Thank you.
senator from the 52nd district. I'm sorry, did you?
I yield.
I'm sorry. The senator's yielded. Senator from the 52nd district is recognized for the purpose of speaking to the bill and its amendments.
Thank you, Mr. President. I'm here to speak to this amendment too. I find myself in a little bit of a strange position because I'm a PA in anesthesia, and I'm going to get up here and defend the CRNAs. Well, the CRNAs keep me from practicing in Tennessee. So there's sometimes not the best relationships between the two of us. However, what they would be doing has nothing to do with giving anybody any pills. They're not giving anybody any pills in these pain clinics. And I read his letter, and he talks about opiate and all that. These are the doctors doing it. They're not doing it. Has nothing to do with any pills being given out before the bill or after the bill. They are not putting anybody to sleep. We read anesthesia, and I know a lot of people think we're putting people to sleep or something here. Nobody's getting put to sleep. This is not general anesthesia. This is injections that are being given. They've been doing them for years. This would simply allow them to keep doing what they're doing. I think it's safe what they're doing. They've got a great track record at it. They go to school. They get their bachelor's in nursing. They have to have a year of critical care training in a hospital, and they go back to school for 3 years and get training. These are well-trained individuals, even though maybe my guys like to think we're better trained at times. So making this a scope of practice issue, I think this is the wrong time to do this on this bill, that we should pass the bill as it is, and if we want to look at general scope of practice, that should be a separate issue. And if there's no questions, I'll yield the well.
There are questions, Senator. The senator from the 41st district is recognized.
Senator Yield.
I'll yield.
Senator, do you think that if there were a lot of people had been injured in this procedure, a procedure that many nurses have done for many years, and if a physician was in the building, not in that room, nurses have done this for many years, do you think if there had been a lot of damaged individuals that we would have heard a lot of testimony of that, a lot of statistics, and possibly some cases?
I think we would have, but I also think the bigger point is that if we want to look at this, we need to look at it and look at the data in a more structured way and make that decision at a later date, and not get that involved in this bill that has nothing to do with scope of practice, in my opinion.
Senator from the 20th district is recognized for the purpose of asking a question. Senator from the 20th district, your light is on. The great senator from Houston County waves off. The senator from the 1st district.
Does the senator yield?
I yield.
Isn't it true that the CRNAs are doing this now, and this is within their scope of practice, and they've been doing it for years?
They have been doing it for years, and like I say, I usually don't defend them because they're my competition, but I feel like I have to.
Well, I'm right there in the same boat with you. But isn't it true the reason this bill is here is that the big bill that we did relating to pill mills and closing down the pill mills, that they were left out of the conversation, and this left it ambiguous or unclear relating to their practice in an outpatient setting. Isn't that true?
The senator from the 1st is correct. This is cleaning up a mistake in a bill in the past that did do a great job of tightening down on these pill mills. They weren't giving out any pills before, and they will not be giving out any pills after this bill, irregardless, and they won't be putting anybody to sleep.
So does the senator further yield?
I yield.
So isn't it true that they are operating under a physician's order? And most of the time a physician is in the building when they're doing these procedures. And isn't it also true that, as you said, they're not prescribing pills, and because of doing these regional blocks or these epidurals, that we're actually prescribing, well, the physicians or PAs are prescribing less medicines?
They are prescribing less medicine, and in many cases, it cuts down on pill use, because a lot of times people have pain situations and you can block the nerve and take the pain away, where opiates quit working after so many days, and it's really a more effective way and doesn't get people addicted to drugs.
Thank you, Senator.
There are no further questions, Senator. Senator yields the well. Senator from the 45th District, the distinguished chairman of the Senate Health and Human Services Committee, is recognized for the purpose of speaking to the bill.
Thank you, Mr. Chairman, Mr. President, and I appreciate this very vigorous debate, and this debate is not unlike what the debate we had in the Health and Human Services Committee, which is composed of many physicians and people who work in the healthcare profession on a daily basis. And this amendment did not come forward, and that's why we're having the debate on the floor. You are in the minority if you agree with this amendment. You are in the minority if you agree with this amendment. This amendment is about a turf war. This amendment is gutting the bill. As we say down here, we're filleting the fish and we're gutting the bill. You are putting people in danger and out of practice if you agree with this amendment. You can talk all you want about the Attorney General. I'm the chairman of the Health and Human Services Committee. He never came to me. None of his attorneys came to me. None of his attorneys told me they didn't like this bill. It has absolutely nothing to do with pill mills. This is about injections. These people do not write a prescription with your name on it and you go to a drugstore. This has absolutely nothing to do with it. They are trying to make a mountain out of a molehill. These people, these nurse anesthetists have been doing this for years and years and years and years. And inadvertently, when we rewrote the bill a couple of years ago about pill mills and being one of the strongest states in the nation to try and shut them down, they inadvertently wrote them into that. And what they're trying to do is a scope of practice bill restricting them from what their ability to do now. The physician from down on the coast from Savannah explained it explicitly. This is a turf battle. The anesthesiologists are trying to reclaim their role and their money and their ability to be able to control the nurses. It's plain and clear. I wanted to speak just a little bit about what the senator from the 52nd talked about, the level of education. These nurses go to school for a very, very long time. And to be able to become a nurse anesthetist is very, very competitive. You don't say, when I grow up and become a nurse, I want to become an anesthetist. You have to get into the school. They go to school for 4 years, postgraduate education from high school. They get their bachelor's degree. Most of them get their master's degree because it is so difficult to get into these schools. They have to go to work. They have to have a work record. You can't just keep going to school, and then you become a nurse anesthetist. That's not the way it is. You have to have a work record to go into it because the schools are so competitive. And then after you get your master's degree, you have to go and complete your semesters up to 3 years to become a nurse anesthetist. They're talking about the danger of injecting into the spinal cord and the possibility of becoming paralyzed. Well, guess what? Guess what these people do all day long? They put the intubation into their lungs so that they can breathe. If they quit breathing, they're doing this 10 times a day to people. 10 times a day. So if you quit breathing, that's the person that has the experience that is doing it all day long, every day. That's the people I want intubating me because they're the experts at it. I don't care if you're a nurse, a doctor, whatever you are, the experience matters because you're doing it all the time. Repetition does matter. They're going to do it correctly. So I ask you not to gut this bill. I ask you to defeat the amendment. It's now labeled as Amendment Number 1. I ask you on behalf of the Health Committee and most of the members of the Health Committee who agreed with it that you didn't have to come to this floor debate to be able to have to vote on this. I ask you to defeat Amendment number 1 to protect, in particular, your rural health care areas, to allow the business as usual to continue as the business of usual of taking care of health care in Georgians. I yield the well.
There are questions, Senator. Senator has yielded. For purposes of clarification, the pending amendment, even though Amendment 1 has been withdrawn, is still Amendment 2. The question is on the adoption of the floor amendment by the senator from the 46th District, the distinguished Senate Majority Leader, to the committee substitute. Is there objection to the adoption of the floor amendment to the committee substitute? All those in favor, rise, stand, and be counted. Senator from the 29th.
Mr. President, I move the yeas and nays.
Are there more? Does anyone wish to join in that request? 5 having requested a roll call ballot on amendment number 2. We'll have a recorded vote. All those in favor of the adoption of the floor amendment by the senator from the 46th District to the committee substitute will vote aye. Those opposed, no. The secretary will unlock the machine. Senator from the 45th.
Mr. President, is it not true that the Health and Human Services Committee requests a red vote, a no vote on this particular amendment number 2, a red vote?
Chair is sure the senator knows of what she speaks. Senator from the 46th District. The 46th District.
Isn't it true that the current law allows these type of services been done only as provided by medical treatments to services defined by the Composite Medical Board? And this law will strike that language and let them run whatever type of treatment they want to with no regulation and no physician on site without this amendment.
I'm sure the chair believes that the senator knows of that of which he speaks. On the adoption of the floor amendment to the committee substitute, the ayes are 12, the noes are 39, and the floor amendment to the committee substitute is lost. Question now is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing no objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to the agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears no objection, and the report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears no objections, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the ayes are 42, the noes are 8. The bill having received the requisite constitutional majority is therefore passed. Chair recognizes the senator from the 9th District.
759? Are we doing special order? Thank you, Mr. President. I move that the Senate adhere to its amendment to HB 904 and that a conference committee be appointed.
Read the caption of the bill.
House Bill 904, Representative Strickland of the 111th and others, a bill to be entitled an act to amend Chapter 8 of Title 34 of the OCGA relating to employment security so as to change certain contribution rates and credits, to change certain provisions relating to rate of employer contributions, to extend certain provisions relating to variation in standard rate and for other purposes. Mr. President, that completes the order.
Is there objection to the motion? Chair hears no objection, and the motion is adopted. Chair has been directed to appoint to the conference committee senators from the 9th District, the senators from the 13th District, and the senator from the 29th District. Chair recognizes the senator from the 7th District, who is not at his desk. Chair recognizes the senator from the 23rd District. The 23rd District.
Thank you, Mr. President. I move that the Senate adhere to its substitute to HB 205 and that a conference committee be appointed.
Secretary will read the caption of the bill.
House Bill 205, Representative Rice of the 95th and others, a bill to be entitled an act to amend Chapter 5, Title 40 of the OCGA relating to driver's licenses so as to require a driver who refuses blood alcohol concentration testing as required by implied consent laws or any offender convicted of DUI and for other purposes. Mr. President, that completes the order.
Is there objection to the motion by the senator from the 23rd District? Chair hears no objection, and the motion is adopted. Chair has been directed to appoint to the conference committee the senators from the 23rd District, the 18th District, and the 54th District. Chair recognizes the senator from the 54th District.
Thank you, Mr. President. I move that the Senate adhere to its substitute to House Bill 876 and that a conference committee be appointed.
Secretary will read the caption.
House Bill 876, Representative Perkle, the 155th, and others, a bill to be entitled an act to amend Chapter 6 of Title 4 of the OCGA relating to livestock dealers and auctions and for other purposes. Mr. President, that completes the order.
Is there objection to the adoption of the motion by the senator from the 54th District? Chair hears no objection, and the motion is adopted. Chair has been directed to appoint to the conference committee the senators from the 50th District, the 7th District, and the 13th District. Senator from the 40th District is recognized.
Thank you, Mr. President. I ask for unanimous consent to remove HB 1025 from being tabled.
The Secretary will read the caption. Is there objection to the motion by the senator from the 40th District? Chair hears no objection, and the motion is adopted. The Secretary will read the caption to House Bill 1025.
House Bill 1025, Representative Taylor of the 79th and others, a bill to be entitled an act to amend Article 4 of Chapter 10 of Title 15 of the OCGA relating to violation of ordinances of counties and state authorities so as to change provisions relating to service of accusations over citations for violations of ordinances under certain circumstances derived for judgments when service is preferred under such circumstances, derived for related matters, repeal convicted laws, and for other purposes. Mr. President, the Committee of the Senate on Judiciary recommends that this bill be passed by substitute, recommended by Senator McCooney, the 29th. Mr. President, the Senate Judiciary Committee offers the following substitute House Bill 1025, a bill to be entitled an act to amend Article 4 of Chapter 10 of Title 15 of the OCGA relating to violation of ordinances of counties and state authorities and for other purposes. Mr. President, Senator Miller of the 40th offers the following amendment number 1 to the substitute to House Bill 1025 by replacing lines 36 through 39 with the following: service under paragraph 1 of the subsection shall not be authorized until there has been at least one attempt at personal service on the accused. Prior to the such attempt at personal service shall only be required if the accused resides or has and for other purposes. Mr. President, Senator Hill, the 6th, and others offer the following amendment number 2 to the substitute to House Bill 1025 by striking line 4 and inserting in lieu thereof the following: circumstances derived for judgments when services preferred under such circumstances and for other purposes. Mr. President, Senator Miller of the 40th and others offer the following amendment number 3 to the substitute to House Bill 1025 by replacing lines 33 and 34 with the following: mailing a copy of it by registered or certified mail or statutory overnight delivery to the owner of such premises at the address and for other purposes. Mr. President, Senator Hill of the 6th offers the following amendment number 4 to the substitute to House Bill 1025 by striking line 4 and inserting in lieu thereof the following: circumstances derived for judgments when service is preferred under such circumstances and for other purposes. Mr. President, that completes the order.
Chair recognizes the senator from the 40th District, distinguished chairman of the Senate Higher Education Committee, to present the bill.
Thank you, Mr. President. The distinguished senator from the 41st and I are happy to present this bill to you on behalf of DeKalb County. When we abolished the Recorder's Court last year, we didn't quite do it right in DeKalb County, so we have to make an amendment for the Magistrate Court. And what this is, it deals with service for when property, it's conditions of property, it's posting the tack, we call it tack and mail. The bill itself, the substitute, there's an amendment 1 that I'm going to ask for unanimous consent to be withdrawn. The distinguished senator from Fulton is going to speak to amendments 2 and 4. And if you remember, the senator from the 41st passed an earlier amendment on a local bill. Amendment number 3 just tracks the same language, so nothing is in error. At that point, we'll fix the problem. If there are no questions, I yield the well.
There is a question, Senator. The senator from the 54th District is recognized.
Thank you, Mr. President. Senator, will you yield?
Yes.
Senator, I appreciate your hard work on this bill, and I just want to make a point as to Amendment 3. Isn't it true that there's at least a rational basis for establishing the differentiated structure for in and out of state parties at lines 11 and 12, including judicial economy and the promotion of registered agents?
You're absolutely correct, Senator.
Thank you. Thank you, Mr. President.
No further questions, and the senator yield. Well, I'm sorry. The senator has yielded the well. The author spoke to Amendment 1. Senator from the 6th District is recognized for the purpose of speaking to Amendment 2 and 4.
Thank you, Mr. President. At the appropriate time, I'm going to ask for unanimous consent to withdraw Amendment 2. Amendment 4, the whole purpose of it is we're dealing with appeals actions, and we're replacing the word action with appeal, which our attorneys are currently doing anyway, so we're just clarifying what's going on in the code. It says action, and we want it to say appeal. If there are any questions, I'm happy to answer them. Otherwise, I will yield the well.
There's a question. The senator from the 41st District is recognized.
Senator Yield?
I do.
So it's your opinion that this amendment, while serving your purpose, won't change the underlying effect of 1025 and won't have any deleterious or negative impact on it?
Correct, Senator, and that's not my intent at all. And I also think that it's not going to happen. So the underlying bill deals with bringing an action, and the amendment deals with appealing decisions from administrative agencies. So both are questions of procedural law, but my issue just deals with the appeals process.
There are no further questions.
Thank you.
Senator. The author of the bill spoke to amendment number 3. The senator from the 40th District is recognized.
I ask for unanimous consent to withdraw amendment number 1.
The senator from the 40th District has asked unanimous consent to withdraw amendment number 1. Is there objection to that request? If not, the request is granted and amendment number 1 is withdrawn. Senator from the 6th District is recognized.
Mr. President, I ask for unanimous consent to withdraw Amendment 2.
Senator from the 6th District has asked unanimous consent to withdraw amendment number 2. Is there objection to that request? If not, the request is granted and amendment number 2 is withdrawn. Question now is on amendment number 3. Is there objection to the adoption of amendment number 3? Chair hears no objection, and the amendment is adopted. Question now is on the adoption of amendment number 4. Is there objection to adoption of the amendment? Chair hears no objection, and amendment 4 is adopted. Question now is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing no objection, the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears no objection, and the report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears no objections, and the main question is now ordered. Shall this bill pass by substitute? The question is on the passage of the bill. All those in favor will vote aye. Those opposed, no. The secretary will unlock the machine. You need to vote. Recognized? Yeah, you stand by. On the passage of the bill, the ayes are 47, the noes are 0. The bill, having received the requisite constitutional majority, is therefore passed. The senator from the 17th district is recognized.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 423 as amended.
Secretary will read the caption.
Senate Bill 423 by Senator Jeffries of the 17th and others, a bill to be entitled an act to reestablish the Board of Commissioners in Newton County to supersede the laws pertaining to the governing authority of Newton County, to provide for a Board of Commissioners, Commissioner Districts, a Chair of the Board, a County Manager, a Clerk to the Board, and ethics provisions, to provide for meetings and for other purposes. Mr. President, that completes the order.
Senator from the 17th District, the distinguished chairman of the Senate Regulated Industries and Public Utilities Committee, is recognized for the purpose of speaking to his motion and amendment.
Thank you, Mr. President. Senate Bill 423 was a local bill for Newton County, and all this does is moves the actual effective of the bill to be January 1st, 2017. That's the amendment. If there's no questions, I'll yield the well.
There are no questions, Senator. Senator from the 17th District has moved that the Senate agree to the House substitute to Senate Bill 423 as amended. All those in favor of the motion by the senator from the 17th District will vote aye. Those opposed, no. The Secretary will unlock the machine. On the motion to agree, the ayes are 44, the noes are 1. The motion has prevailed, and the Senate has agreed to the House substitute as amended by the Senate. Chair recognizes the distinguished senator from the 53rd District.
Thank you, Mr. President. I move that the Senate agree to the House amendment to the Senate substitute to House Bill 727 as amended.
Secretary will read the caption of the bill.
House Bill 727 by Representative Battles of the 15th and others, a bill to be entitled an act to amend Chapter 10 of Title 25 of the OCGA relating to the regulation of fireworks. Mr. President, Senator Mullis of the 53rd and others offer the following amendment. Number 1, to House Amendment to House Bill 727 by deleting all matter from said amendment from beginning to end and replacing with the following. Amend this and for other purposes.
Chair recognizes the senator from the 53rd District, the distinguished and 2 days ago powerful chairman of the Senate Rules Committee, for the purpose of speaking to his motion.
Yes, sir, Mr. President. I only have fair weather friends today, but that's okay. This is the Senate's version of the fireworks bill. We have our local control in there, and also the senator from the 24th Amendment in there, which is the first application for the distribution of fireworks, $5,000. After that, it's $1,500 per location and $1,000 a year after. I appreciate your trust in us, but this is the Senate's position. I appreciate your support.
You do have questions, Mr. Chairman.
All right.
Senator from the 41st District is recognized.
Senator, I appreciate that motion, but I did miss part of it. Could you please repeat that motion that you just made?
My motion, I move that we support the Senate position. Now, I had to go back to my seat and read all that stuff. Huh? I said as amended. You're just, okay, I remember that. Thank you, Mr. Leader. I appreciate your support.
The senator from the 45th District is recognized.
Mr. Chairman, would you yield?
Of course I would.
Mr. Chairman, so you're agreeing with this amendment, which is the Senate's position, and I wanted to ask a question about the pop-ups, you know, the businesses that we call pop-ups, that they are not included in this, and the brick and mortar is that not correct?
That's correct. Now, we do have portable units that we passed last year, and that's the National Fire Prevention Association portable units, which isn't tents, they're portable structures, and they're all in the safety arena. And that's still limited to how we did it last year, as 2 per standing facility for nonprofits and 1 at least.
Could you, Mr. Chairman, just kind of give us a scenario of how you see these bills evolving the rest of the night?
Say that again.
How you...
I just didn't understand you.
Could you tell us how you see these fireworks bills evolving the rest of the night?
I'd say this would be the ending case.
So this is the end?
Yeah, they're going to, I hope they agree to the Senate's position, which has the local control that was needed for the metro area, and it is in there on our position. Okay. Thank you.
There are no further questions, Mr. Chairman.
Appreciate your support.
The senator from the 53rd District has moved that the Senate agree to the House Bill 727. Sorry, I'm not following the script. The senator from the 53rd District has moved that the Senate agree to the House amendment to House Bill 727 as amended. All those in favor of the motion by the senator from the 53rd District will vote aye. Those opposed, no. The secretary will unlock the machine. On the motion to agree, the ayes are 49, the noes are 0. The motion has prevailed, and the Senate has agreed to the House substitute to House Bill 727 as amended. The senator from the 21st district is recognized.
Mr. President, I move that the Senate agree to the House substitute to Senate Bill 307 as amended by the Senate.
Secretary will read the caption of the bill.
Senate Bill 307 by Senator Beach of the 21st and others, a bill to be entitled an act to amend Code Section 32-6-51 of the OCGA relating to erection, placement, or maintenance of unauthorized structures within rights-of-way of public roads and authorization of commercial advertisements by a transit agency so as to provide for definitions relative to advertising, provide for related matters, and for other purposes. Mr. President, Senator Beach of the 21st offers the following amendment number 1 to Senate Bill 307 by deleting lines 5 through 17 and inserting in lieu thereof the following requirements of the article to provide for related matters to appeal convicting laws and for other purposes, and by deleting lines 53 through 123. Mr. President, that completes the order.
Chair recognizes the senator from the 21st district for the purpose of speaking to his motion and amendment.
Thank you, Mr. President. What I bring before you is Senate Bill 307 that passed this body 53-0. It dealt with digital advertising at bus stops and transit stops. What happened is the House added some tow truck language, and all we are doing in this amendment, we are stripping out the tow truck language and going back to the original bill. So I would ask for your favorable consideration. Mr. President, if there's no questions, I yield the will.
There are no questions, Senator. Senator from the 21st district has moved that the Senate agree to the House substitute to Senate Bill 307 as amended by the Senate. All those in favor of the motion by the senator from the 21st district will vote aye. Those opposed, no. The secretary will unlock the machine. Senator from the 54th district is recognized.
Thank you, Mr. President. Parliamentary inquiry.
State your inquiry.
If the senator stated that we are striking out what the House substituted in, would we be doing the same thing as insisting?
It is functionally the same motion as insisting.
Okay, thank you very much, Mr. President.
You've confused everyone with your inquiry. Senator from the 19th district is recognized.
Parliamentary inquiry.
State your inquiry.
Would insisting, if the goal is to get to a conference committee?
No, the goal is not to get to conference committee, which is why the motion was stated in the manner it was stated. On the motion to agree, the ayes are 41, the noes are 0. The motion has prevailed, and the Senate has agreed to the House substitute to Senate Bill 307 as amended by the Senate. Senator from the 9th district is recognized.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 270 as amended by the Senate.
Secretary will read the caption.
Senate Bill 270 by Senator Martin of the 9th and others, a bill to be entitled an act to amend Part 3 of Article 4 of Chapter 11, Title 16 of the OCGA relating to carrying and possession of firearms so as to authorize persons who are qualified retired law enforcement officers to carry a handgun anywhere within the state to provide for related matters and for other purposes. Mr. President, Senator Martin of the 9th and others offer the following amendment number 1 to the House substitute to Senate Bill 270 by replacing lines 7 through 17 with the following: provide a definition to revise penalty provisions to amend Title 42 of the OCGA and for other purposes. Mr. President, that completes the order.
Chair recognizes the senator from the 9th district for the purpose of speaking to his motion and amendment. Senator from the 9th district is recognized.
Thank you, Mr. President. Bring to you, wanted to
share with you guys the amendments that were made to this bill so you can make an informed decision here. I believe this is a good decision. First of all, Section 1 is going to make it unlawful for a person to impersonate a veteran with an intent to deceive. This is coming from Representative Terry Rogers. Excellent bill, good piece of legislation. 2 is going to add additional rules for false 911 calls and make it easier for us to impose those penalties. We passed 1060 out of here earlier this week, and my bill had been used as a vehicle if it was necessary to have it to move 1060 if it was necessary. Because we passed that, we are removing the language in the sections in here that included the language on HB 1060, so this will remove those. And then finally, we're going to allow parole officers who retire in good standing to be able to receive their badges and guns at retirement. If there are no questions, I will yield the well.
There is a question. The senator from the 39th district is recognized.
Will the senator yield?
Yes, sir, I yield.
You know, I apologize, but I didn't get your full discourse on the state of this piece of legislation. You said it had been a vehicle for 1060.
It was a vehicle for 1060, and that has been removed from this legislation by my amendment.
Okay. And the amendment that we have on our desk, is that correct?
That is what that amendment accomplishes. Yes,
Okay.
Senator.
Will the senator further yield?
Of course, Senator.
Can you give us just a thumbnail on what it does contain at this point?
I did just attempt to do that. The first part of it does, it adds, Section 1 makes it unlawful for someone to impersonate a veteran with intent to deceive. That's Section 1. Section 2 adds additional rules for false 911 calls, which people are calling, they call that swatting. When you call 911 for the purpose of causing a reaction and getting that on videotape, they call that swatting. This adds additional rules to allow our local jurisdictions to be able to respond better to that, and adds additional penalties. And then in section, further back in Section 9, that allows our parole officers to be able to receive their badges and guns when they retire with good service.
And will the senator further yield?
I yield.
And then my assumption is confirm that sections 3 through 8 are excised, taken out of the legislation. Is that correct?
I'm sorry, Section 8, not 3, it's 3, 4, 5, 6, 7, and 12. That was the contents of 1060. Section 8 allows the warden to designate a person or it allows him to designate his chief or staff to issue a warrant for the penal institutions, the warden of such institutions. Forgive me for leaving that out.
There are additional questions, Senator. The senator from the 23rd district.
Thank you, Mr. President. Will the senator yield?
I yield.
Have you, in effect, with your amendment, taken out the provisions that were related to HB 1060?
Yes, Mr. Chairman. Because we already acted on 1060, we removed every section in this piece of legislation that had been added in that related to 1060. And those were sections 3, 4, 5, 7, and 12.
Thank you.
There are no further questions, Senator.
Thank you. I yield the well.
The senator from the 9th district has moved that the Senate agree to the House substitute to Senate Bill 270 as amended by the Senate. All those in favor of the motion by the senator from the 9th district will vote aye. Those opposed, no. The secretary will unlock the machine. On the motion to agree, the ayes are 42, the noes are 1. The motion has prevailed, and the Senate has agreed to the House substitute to Senate Bill 207 as amended by the Senate. Chair recognizes the senator from the 17th District.
Thank you, Mr. President. I move that the Senate adhere to its disagreement to the House substitute to Senate Bill 199 and a conference committee be appointed.
Secretary will read the caption of the bill.
Senate Bill 199 by Senator Jeffries of the 17th and others, a bill to be entitled an act to amend Chapter 2 of Title 21 of the OCGA relating to primaries and elections generally so as to provide a definition to prohibit certain activities within close proximity to polling places, provide for related matters and for other purposes. Mr. President, that completes the order.
The senator from the 17th District has moved that the Senate adhere to its disagreement to the House substitute to Senate Bill 199 and that a conference committee be reported. Is there any objection appointed? Is there any objection to that motion? Chair hears no objection and the motion is adopted. Chair has been directed to appoint to the conference committee senators from the 11th District, the 17th District, and the 30th District. The chair would like the senators from the 56th and 32nd and 23rd districts to stand by. Chair recognizes the senator from the 9th District.
Thank you, Mr. President. I ask unanimous consent to remove HB 759 from the table.
Secretary will read the caption.
House Bill 759, Representative Willard of the 51st and others, a bill to be entitled an act to amend Article 3 of Chapter 19 of Title 15 of the OCGA relating to the regulation of the practice of law so as to provide that certain activities by financial institutions shall not constitute the unauthorized practice of law, to provide for related matters to be convicting laws and for other purposes. Mr. President, the Committee of the Senate on Banking and Financial Institutions recommends that this bill do pass by the submitted by Senator Jones on the 25th. Mr. President, that completes the order.
Senator from the 9th District has moved that House Bill 759 be removed from the table. Is there objection to that motion? Chair hears no objection and the motion is adopted. Chair recognizes the senator from the 9th District for the purpose of speaking to the bill.
Thank you, Mr. President. Colleagues, I'm bringing HB 759. What this does is clarifies in our code that financial institutions that are federally insured will be treated as banks. Our current code says banks. We're adding financial institutions insured by the FDIC.
There are no questions, Senator. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears no objection and the report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears no objection and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. The secretary will unlock the machine. Senator from the 56th District, stand by. On the passage of the bill, the ayes are 43, the noes are 0. The bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 56th District.
Thank you, Mr. President. I ask unanimous consent to move House Bill 216 off the table.
Secretary will read the caption.
House Bill 216 by Representative Gravely of the 67th and others, a bill to be entitled Enactment Part 1 of Article 8 of Chapter 9 of Title 34 of the OCGA relating to general provisions related to compensation and for other purposes. Mr. President, the Committee of the Senate on Insurance and Labor recommends that this bill do pass by substitute.
Chair recognizes Senator from the 56th District has moved that this House bill be removed from the table. Is there objection to the adoption of that motion? Chair hears no objection, and the motion is adopted. There are 4 amendments to read. The Secretary will read the amendments.
Mr. President, Senator Albers of the 56th offers the following amendment number 1 to House Bill 216 by deleting line 30. On line 30, the words clear and convincing, replacing them with the following: a preponderance of the. Mr. President, Senator Bethel of the 54th offers the following amendment number 2 to House Bill 216 by beginning striking with the word is on line 29 and continuing through the end of the line. Mr. President, Senator Bethel of the 54th offers the following amendment 2A to the amendment number 2 to House Bill 216 by adding at line 4 and by beginning striking with the word firefighters and for other purposes. Mr. President, Senator Bethel of the 54th offers the following amendment number 3 to House Bill 216 by striking the words is cancer which on line 28 and for other purposes.
For what purpose does the senator from the 54th District rise?
Thank you, Mr. President. Amendment 3 is an effort to correct an inartfully drawn Amendment 2 and 2A. And in light of that, I'd ask unanimous consent that Amendments 2 and 2A be withdrawn.
Senator is recognized for that purpose. Senator from the 54th District has asked unanimous consent to withdraw Amendment 2 and 2A. Is there objection to that request? Chair hears no objection, and the request is granted. Amendment 2 and Amendment 2A are withdrawn. Chair recognizes the senator from the 56th District for the purpose of speaking to the bill and his amendments.
Thank you, Mr. President. House Bill 216 has been worked on for over 2 years, and it would permit firefighters who contract cancer as a result of their exposure to toxic chemicals while fighting fires and other duties that is not currently covered under the Workmen's Compensation Act. Current law says that occupational diseases, which are those that are caused by a job that are covered in the Workmen's Compensation Act, except if it's an ordinary disease of life. And while cancer could be considered an ordinary disease of life, the type of exposure that a firefighter has is very different. And even though medical evidence shows that it came from the job, those employees today have no remedy whatsoever under the current law. House Bill 216 started out by creating presumption in favor of an employee and applying to all employees in Georgia. However, in order to reach consensus and work in good faith with all parties, we scaled that back. Employees are opposed to rebuttable presumption, so the sponsor of the bill in the House and I worked together to agree to remove that, to make sure it was a narrowly focused bill so we could focus on what would be the preponderance of medical evidence, which we'll talk about in a minute more. Now, there are a few cities and counties, and unfortunately some people out in the hallway who are arguing unvalid points. The standard is unprecedented to use clear and convincing in any other area of workmen's compensation. In fact, every single area of workmen's compensation uses a preponderance of evidence. My floor amendment to House Bill 216 changes just those couple of words. And to those couple of words, it will mean to only a very few everything in the world. It is very important that we do this for the men and women that put their lives on the line every single day. I have been a firefighter for over 2 decades, coming on 3. As I stand here today, some of my brothers and sisters are no longer with us. In fact, when everybody else rushes out, they're the people you expect to rush in. They're the folks that you're calling to protect you, to protect your family, and to protect the people that we're all sworn to protect. The standards of workman compensation cases is very clear. You've got letters from all the different firefighter associations on your desk right now. 35,000 men and women serve you as firefighters today. 35,000. And they are behind this 100%, as are many other states. In fact, the Idaho Senate just passed this unanimously. Because of job-related cancers in firefighters, one single incident could destroy their lives later on, where we could offer them just a little bit of help. Now, this will impact a very small amount of people. I do want to talk one more important part, where the U.S. Supreme Court stated that a preponderance of evidence is all that is required in most civil cases, unless particularly important individual interests are at stake. The higher standard has been applied in cases involving fraud or bad faith conduct. Much to the chagrin of the insurance company, in 2003 decision by the Arizona Court of Appeals held that an insurance company claiming that fraud by the insured party was sufficient to void the policy and relief for the insurance company of its payment was an obligation that had to be proven by clear and convincing evidence. Even the Supreme Court and the Court of Appeals say clear and convincing evidence is not necessary. Let me summarize real quick. This simply allows firefighters who have been diagnosed with cancer the ability to submit medical evidence in a workman's compensation case. We work diligently with all parties. The burden of proof is still on the firefighter. This guarantees them absolutely nothing but their opportunity to stand in front of the judge. This is not presumption. This is a preponderance standard that is equivalent with everything else. We have done our research. California and Wisconsin have done the research on how much this costs. It is 2/1000ths of 1%. That's 0.0002 of 1%. So today you're going to have to make a decision to vote for amendment number 1, and either you're going to listen to a handful of people in the hallway who are giving you misrepresentation, or you're going to listen to 35,000 firefighters and the real research and tell them you've got their back. Because the other 365 days a year, folks, they've got your back. So I'm going to ask you to vote for amendment number 1. And while I appreciate my friend, the senator from the 54th, and his willingness to expand this to all areas, that is not what the bill came over for, and something we should vet out in committee next year. I would love to work with him on that. But I do not want to lose the opportunity to help our firefighters while expanding outside its means. So I'm going to ask you to vote down Amendment 3 now, with my commitment to work in good faith next year to fix that. If there are no questions, I will yield the well.
There is a question, Senator. The senator from the 47th District is recognized.
Thank you, Mr. President. Would the senator yield?
Certainly, Senator.
You know, I'm not too good at cancer. I've had some cut off of me over the years, and for me, I've had a great service in public service with local governments, and I can't be more proud of the awards that my fire departments have given me for being there to help them with the fiscal side of things. Now, I'm not crazy enough like the senator from the 56 to go running into a burning building, but I appreciate those that do. So I would ask, can you tell me, maybe just list some of the types of cancers that you're talking about? Because, I've had skin cancer, and I know a little bit about cancer. So can you tell me some of the cancers that we're talking about?
Well, Senator, there are many different types of cancer, and I am not a doctor, but when firefighters are exposed to certain things such as hazardous materials or chemicals, there can be several different types of cancers that come out of that. In fact, there are many different areas that have been cited and researched that have showed, based on exposure to certain things, that they can have impacted certain type of cancer. But again, understand, this is not a presumption of cancer. It's an opportunity to go in front of the judge and to show the facts and a preponderance of evidence to show that their on-the-job activities caused the specific cancer that they suffer from now.
If you further yield, when I start looking at the types of cancers, I mean, I agree that firefighters put themselves in some dangerous situations, but when we start talking about preponderance of evidence or what's going on with that, tell me how that impacts, say, testicular cancer. Most firemen are men. Said they, when we start looking at firefighters across the country, said they, that's the most common type of cancer for men in their 20s. How would that come into play?
Well, Senator, again, the firefighter only has the ability by this law to go in front of an administrative law judge and present the facts as to why he or she thinks that their specific occupational disease is connected to specific things that have happened throughout their career and their job. So if there is not any facts, then they have no case to go by.
Thank you.
Thank you for your questions.
There are other questions. The senator from the 36th district is recognized.
Thank you, Mr. President. Does the senator yield?
Yes, ma'am.
Senator, I'm sure you, like I and millions of Americans, watched when Congress was dragging their feet on addressing the health needs of those first responders from 9/11 that are suffering here more, decades later with the outcomes that their health is challenged by what they were exposed to that day. And I believe you stated fairly clearly, isn't it true, that a preponderance of states have the kind of language that Amendment 1 would put into your bill?
Boy, Senator, thank you so much for asking that question, and you are absolutely right. A preponderance of states use the preponderance of evidence, which is the standard for workmen's compensation to protect folks just like those who responded after 9/11.
And wouldn't it be good advice to those who may have heard from a township or a municipality, someone that pays has a payroll of first responders and firefighters, that the cost to them is minuscule of changing this language and offering this coverage for our first responders with cancers that are work-related. Whereas for a family who's battling cancer together, it means the world to have that coverage and to know that we have their back. And when you weigh the one against the other, how can you do anything but vote for the firefighters?
Well, Senator, I could not agree with you more. And as mentioned, the cost is so minuscule. California, Wisconsin, 0.001%. And you are absolutely correct that for such a small amount of money, it really draws the same parallel to when this body unanimously passed Ava's Law to help out those with autism, because we knew a small investment meant a huge return for our children, and now we can do the same thing for our firefighters.
That's right, and it gives us an opportunity to do more than lip service for these people who put their lives at risk on a daily basis for us.
Thank you, Senator.
Thank you.
Senator from the 29th district is recognized.
Thank you, Mr. President. Will the senator yield?
Yes, Mr. Chairman.
I believe you touched on this in your general remarks, but I just want to try to get some clarity on this. It appears from looking at the underlying committee substitute and the amendments before us, the primary debate here is on the standard of proof that would be used. And could you just explain why you believe that going to preponderance of the evidence versus clear and convincing is so important?
Yes, thank you, Senator, for your question. And to provide additional clarification, in the Workmen's Compensation Code, there is no place whatsoever that we use clear and convincing. It would be creating a standard that does not even exist today within workmen's compensation. There is a preponderance of evidence which would be consistent, and it would make sure that we're giving the opportunity for that firefighter, if they had been exposed in more than one event, to be able to bring those data points together and, again, simply state their case. It would mean nothing but giving them an opportunity to have their day in court. And I think we owe that to them at the very least.
There are no further questions.
Thank you, Mr. President.
Senator from the 56th has spoken to the bill and amendment number 1. Senator from the 54th district is recognized for the purpose of speaking to his remaining amendment number 3. The distinguished chairman of the Senate Insurance and Labor Committee, the Lion of Northwest Georgia.
Thank you, Mr. President. With all due respect to my friend and former suite-mate from the 56th, I hope you will agree that I am not someone standing out in the hall, that I am here. And so my voice, I guess,
isn't one of those talking nonsense, and I appreciate the reference, and maybe that is appropriate. I don't know what people are saying out there. I got a pretty good idea what I'm going to say in here. Senator from the 56th is right about a lot of what he said, and I want to be clear to you today that I believe that firefighters who contract cancer or frankly other diseases as a result of their performance of their job duties should have access to the workers' compensation system. They should. I believe that they've always been intended to have that access, and I personally believe that the Georgia Court of Appeals denied them and the rest of Georgia that access incorrectly. But I have never sat on the Georgia Court of Appeals, and so I don't have the capacity to inquire as to why they decided their line of cases the way they did. I have worked extensively in the area of workers' compensation outside of my duties here. I take that system very seriously. It is a great compromise that we reached across our country that balances the interest of labor, it balances the interest of judicial economy, and it balances the interest of employers. The idea is you don't have to prove liability to have recovery. The way we are most commonly familiar with workers' compensation is I was injured, something fell on me, my hand was cut, something happened to me at work that required acute or immediate medical attention. And this is not that world. This is a separate part of the Workers' Comp Act. This is the occupational disease provision. This is when your work made you sick. You don't have a date of injury. You don't have a this happened to me. And so to prove an occupational disease in Georgia, you'll see, senators, in the committee substitute, what you have to prove. You have to prove elements A, B, C, D, and E that starts on line 20 and ends on line 34. You have to prove all of those elements. One, you prove them all by preponderance of the evidence. One of those is that the disease that you are suffering from is not an ordinary disease of life, meaning something that people get regardless of their profession, regardless of their exposure, regardless of where they work, regardless of where they were born, people get the disease. Now, the Court of Appeals ruled that cancer, basically by definition, is an ordinary disease of life. Like I said, I think they were wrong. I just don't think that's true. I think your work can cause your cancer. Science supports that. But nevertheless, they did. So let's be clear. Today, the standard for recovery for any Georgian in workers' comp is it cancer? No recovery. No recovery. The senator from the 56th is right. The Workers' Comp Act does not include clear and convincing anywhere else. It also nowhere else includes a specific standard for a single profession. So whichever way you go, we're going down uncharted territory. We're going down uncharted territory. The reason I suggest to you that clear and convincing is the appropriate standard is because the nature of what it is you are trying to prove. You are trying to prove to an administrative law judge, not a jury, not a superior court, this all happens in an administrative setting, to an administrative law judge that something that the population as a whole gets in the regular course of life, you got because of your work. I believe that should require special proof. What sort of special proof? In our committee, we heard testimony from individuals who said an entire battalion responded to a fire at the Centers for Disease Prevention and Control, the CDC. And within, I believe it was 1 year, the entire battalion had the same form of cancer. Senators, that's clear and convincing. You heard the senator from the 56th talk about states that have presumptive responsibility. That's true. There are several states. I can only find a small number of states, I think it's around 3, maybe it's more than 3, that have true presumptive for all cancers. Instead, they have presumptive for specific cancers, ones that have been shown to that legislature in that state to be directly related and linked to cancer. to the occupation of firefighting. And so those states don't have a presumption for all cancer. That's not true. Those states say brain cancer and urinary testicular cancer, those sorts of cancers. Some of them have blood cancers, leukemias and the like. But again, think about what's happening from a policy standpoint. In those states, the legislature has chosen to say, we have received enough evidence to supplant the tribunal. We don't think a tribunal needs to decide whether there was enough evidence in these sorts of cases with respect to these specific cancers. Do you have that evidence? I do not. And I don't think I need it, because there may be a report tomorrow that shows a link between a new cancer and firefighting, and I don't want a list. I want everybody to be able to go to court, administrative court, and say, I can demonstrate that my disease was caused by my work duties. And I don't want a list to determine whether that's the true or not. But I also want to say that requires real proof. That requires real linkage, because it's something that people get. Also, in the states that have presumptive and have preponderance, most of them have limitations that say it has to have been diagnosed while you're employed. While you're employed. I don't want that for Georgia. I think that's a bad standard. I think if I retire and am diagnosed the next day, as opposed to the day before I retire, that should not control whether I am able to gain recovery for my claim. I don't think that's a responsible policy path. Senators, the senator from the 56 quoted an unidentified Supreme Court case talking about clear and convincing requiring a particular interest. The particular interest is we're proving something that happens to everybody happened to me at work. That is a particular interest. I would offer to you it may be the definition of a particular interest. But irrespective of the Supreme Court's holding or verbiage, we're deciding how to open a door that has heretofore been closed. We're deciding how to open it. Now, senators, I'm going to offer to you, I hope that in the 6 years I've been here, that my impression that I've left with you is not that I'm someone who would ever want to withhold something that someone's entitled to. I hope that's not the impression I've given. It's certainly not the way I feel about this bill. And I hope that you see that I thoughtfully take on the policy that we encounter, especially that which comes through the committee I chair. I have worked in workers' comp for a long time. I've considered this bill for a long time. We are opening a door that has heretofore been closed, and it should be opened. It should be opened. Mr. President, I'll speak to my Amendment 3 and apologize to the Senate for the really sloppy amendment drafting that I've done and having to withdraw number 2, and I appreciate the senator from the 3rd making a clarifying amendment to try to effectuate the purpose of Amendment 3. Amendment 3, you see a lot of language there that's in front of you. Let me tell you what it essentially does. It says, if anybody gets to prove that they have a disease caused by their work, everybody gets to. Everybody gets to. I want the firefighters to have access, but I also want the folks who are arson investigators, who are on scene when all the same off-gassing is taking place, not at the same temperatures, obviously a different environment, but the same chemical exposures. I want them to have access if they can prove it. If they can prove it, I think they ought to have access. I think that individuals who are in other high exposure, high risk, nurses in emergency rooms who are stuck with a needle and get hepatitis. Today, the Court of Appeal says, well, people get hepatitis C. You're out of luck. I think if you can prove it came from your work, you ought to be able to get workers' compensation benefit. The last piece I would say to you, senators, is all of these states have come up with solutions that answer the question in their state. And today we're trying to answer that question in Georgia. Some of those presumptive states, 10 to 12, I apologize because I didn't write the number down, they actually handle this through their pension, through their retirement system in their state. Well, that's not what this bill does. And so to compare that would not be apples to apples. They do it through a separate system. Again, many of them are for specific cancers, a specific list. Many of them are for only while you're employed, if you're diagnosed while you're employed, not open-ended as I think ours should be. I think this is the right solution. But if it's good enough for one Georgian, why isn't it good enough for all Georgians? I'm very sympathetic. I am convinced that many firefighters contract cancer and potentially other diseases as a result of their duties. And I think that their employer should be responsible under workers' compensation. I also know that there's a lot of stuff I don't know. And there may be a report tomorrow about some other profession where a disease comes into being at a higher prevalence because of your job duties. This is a serious window we open. Mr. President, I would yield for questions. If there are none, I would yield the well. I really would ask you to vote down Amendment 1 and give your consideration to Amendment 3. You may disagree. You may think it ought to only open for the firefighters, and they certainly deserve our admiration and respect. And if you think that's right, I'll abide by the will of my peers.
You have provoked a number of questions, Senator.
Thank you, Mr. President.
Senator from the 45th District is recognized.
Mr. Chairman, would you yield?
I certainly yield.
Mr. Chairman, is it not true that I have unmitigated confidence in you and your deep depth of knowledge of health care and insurance? Is that not true?
Senator, you are kind to say so. Always hold back a little because I'm flawed like the rest of us.
Would you further yield?
I yield.
Senator, would you say it's not true that a broken bone, a clogged artery in your heart when you're having a heart attack, an aneurysm when you're having a brainstem aneurysm, that those are very definitive diagnoses and that a cancer diagnosis is not? Would you not agree with that?
I would agree that diagnosing cancer and onset and also are far more complicated than an acute occurrence or event.
Would you further yield?
I yield.
Senator, would you, and I don't believe I was in the committee when these questions came up, and I appreciate the committee doing such a fine job on the discussion of this, but one of the issues that I got to thinking about, because I'm a former mayor and a former county commissioner, one of the questions I had was, I know in Gwinnett and Walton, in some of the counties, we have professional firefighters who work for the counties, but they may live out in another area, sort of say like the hinterland. They may live out in Barrow or Jackson or further out. So if they work for a county and then they volunteer at another location for a city or a county, how would you decipher where the injury occurred? I know they said they kept records, but how would you get that evidence?
Well, Senator, I think the answer is it would be difficult, and in that respect, I'm exceptionally sympathetic to firefighters because you would be trying to prove that your exposure in one place or the other. The occupational disease statute doesn't really account for multiple employers being responsible. That would be a real challenge for a claimant in that situation. But they would, again, be looking for where the exposure took place, because oftentimes they would say, hey, you know, I may work here, but I've only been in a fully involved house fire, and it was with these sorts of elements in it, which they do record, thankfully. And so that's what they would be focusing on. Presumably, if 97% of workers, or 97-something% of workers' comp claims that are allowed are admitted in Georgia by our municipal and local government employers. That was their testimony. These cannot be allowed because there's no allowance in state law for them to be compensable. So hopefully, If there's good evidence of exposure and good evidence of correlation, those would be accepted claims. Remember, you can, as on the employer side, you can accept a claim for workers' comp. So hopefully if there's real correlation, you're accepted, and we're not even talking about clear and convincing because the employer's stepping up and is doing the right thing. But it would be a difficult thing to prove if you had two exposures or experiences, even if the second employment wasn't necessarily firefighting. If, for example, you were a painter and you were exposed to fumes and the actual condition may be related to your lungs, those would be difficult issues. Regardless of standard, they would be difficult.
Would you further yield?
I yield.
Is it not true that firemen work shifts and they do have a lot of other part-time jobs? Is that not true?
The firefighters I know are extremely diligent and hardworking individuals, and so my experience with them is that yes, they work tirelessly to provide for themselves and their families.
Yes, sir, I have to agree with you that, and I've known many too. The other question I had is about the example you gave, like with public health nurses. One of the questions that got brought up in the committee was about, a firefighter does not know what kind of situation that they're going into. Well, if you're a public health nurse and your fiduciary responsibility is to be sent out to an emergency like the floods we had down in Columbus and down in that area, public health nurse wouldn't know either. And she could be going out and giving IVs and get stuck and get that hepatitis C that costs $100,000 a year to treat. Is that not true? I mean, aren't there other professions that they go to the scenes, EMS? How many other professions go?
I don't have a chronicle or account, and Senator raises a very good point in the discussion earlier with the Senator from the 36th and the Senator from the 56th. Of course, with respect to the 9/11 first responders, it's not firefighters only. It's also the other, the police officers and other first responders who are on the scene who, again, from where I sit, have clear and convincing evidence that they were made ill by doing their job duties. But there are
Senator,
others.
my last question.
I yield.
Would you not say that mayors and county commissioners, that this bill is one of their top priorities, and that's who we've been getting phone calls from because of exactly what you're talking about? It's a slippery slope. We start out with the firefighters, but then we start going to the other professions, because how do you cherry pick who is the most important?
Yeah. Senator, I do know that there are certainly a lot of local governments that are concerned, as we all would be if something that previously uncovered became covered and we were responsible for paying the bill. We would all be attuned to that. And the last piece on that I would say is I have not seen the reports. I think it sort of reinforces the issue that the case has been made only in a very limited format that the Senator from the 56 talked about these Wisconsin and California studies. I suspect, given those numbers, that those are as a total spend of all workers' compensation, which is not the same thing as a proportion of those firefighters or first responders, because those paying the premiums are going to be on the limited scale, not the total spend scale. But I don't know. I haven't seen it. And again, I think we ought to be open-eyed and cautious when walking down a new path for coverage.
Ladies and gentlemen of the Senate, the hour is late. There are 26 bills on the table, at least 55 special orders, several conference committees appointed. This is a very important bill. It deserves our full attention and consideration, but be mindful of how little time we have left and how much work we have to do. Senator from the 6th District is recognized.
Thank you, Mr. President. Senator Yield.
I yield.
All this conversation's great. Everybody's for the firefighters, but a lot of us are not attorneys. Can you quickly tell us the difference between preponderance and clear and convincing? Because the bottom line is, as I understand it, you still have to prove in a court of law on preponderance.
Yeah, that's correct, Senator. I'll do my best. It's been a while since I've sat in a law professor's room. So right now, the standard is you cannot recover, so you can't prove anything. Preponderance of the evidence is what's considered the lowest evidentiary standard, and it means more likely than not, sort of the scales just tip just past the center. The one we're all most probably familiar with is beyond a reasonable doubt. That is the highest standard that can be asked for in a court of law, and it's usually only used in a criminal setting. And then there's clear and convincing. And you will see a lot of case law about what clear and convincing means. Essentially what it means is that it's enough to sort of convince you. It's no longer just the balancing, it's I have a reasonable amount of confidence. It's not beyond a reasonable doubt, but I'm reasonably confident that this is the truth as opposed to just tipping the scale.
But final question, do you yield?
I yield.
The individual still has to come with strong evidence in the preponderance situation. So, I mean, you gotta prove. So that's why I'm just, I'm not convinced that it needs to go all the way up to clear and convincing.
Is there a question there?
Don't you agree?
Thank you, Senator. I understand your interest. I will say that having worked in the administrative law courts, with all due respect to a lot of my friends who work there, my experience is preponderance of the evidence in an administrative setting often tends to mean any evidence. That's the actual experience. So if you bring it forward any evidence, you're going to get a recovery. I believe strongly that when your purpose is to prove something that, again, ordinarily has happened to you for an extraordinary reason, that it's appropriate for us to do that. I will say this: if we find that that's wrong, if we find that standard becomes unattainable in cases where we think the evidentiary standard should have been satisfied, we have the power to adjust that standard. That's fine. But I think we ought to do it cautiously, appropriately, mindfully of the fact that we are doing this for the broad spectrum as the bill is written currently, for all cancers. My amendment would say for all diseases. I don't understand why cancer would be any different than some other disease that you contracted at work, if you can prove that your work caused it.